May it please your lordship. See, in this case, service is completed lordship, and I and myself also engaged lordship on 19 as a special public prosecutor of Nia lordship to assist the senior advocate Disokia lordship.
Paper book has been prepared.
Paper book we have received lordship.
Okay.
We have received last week. We have
Then we
received.
can fix a date of hearing.
Hearing.
We last order we said list after preparation of paper book.
Lordship.
So since paper book is prepared,
Lordship.
tell us the date of your convenience.
Third week of September lordship. Third week of September. Possible lordship.
Okay, we'll put a third week of because both of us needs to be in the principal seat. We put third week of September at
Lordship.
any convenient day.
Lordship.
In terms of the order dated 23/4/2025, the paper book has been prepared. Full stop. List for hearing in the third week of September. Third week of September. Third week. Okay.
16 or 18 years.
No, we'll not put a date.
Lordship. As and when lordship book
Yes.
available.
Third week of September.
Lordship. Always. We have filed it today. Can your lordship take it tomorrow?
Motion.
Motion.
Motion is. No problem.
Much okay.
May I please, Lordship. Lordship, as regards item number 8, we have filed a rejoinder that is not actually with the record. Lordship may kindly call for the record.
8 is a review petition.
Lordship,
Okay. You have served on the other side.
yes, Lordship,
Okay. Get it.
Lordship. Lordship, another prayer, Lordship. Lordship, I have a prayer for listing of matter of for today, Lordship.
Only motion.
Motion, Lordship.
What is the urgency?
Lordship, because connected matter is fixed today, so Lordship, this is little urgency.
What is the connected matter?
Lordship, it is in court number 18. Lordship,
So you have to make a mention in code number 18 if it's connected.
this is a senior bench file.
But we have to know the urgency.
Lordship.
Only because one connected matter is there. What is the urgency?
Lordship, because that is on the verge of Lordship. Because we are the Anchalik Panchayat and that is like Lordship.
No, what is the urgency in your case? If you convince us of the urgency, we will allow you.
Lordship, because we are connecting, there is a market which we are not able to function. And if we are the interested party, Lordship, so we want to file this, this petition may come up.
We don't find urgency.
Lordship, actually, the matter is in the fix for admission and we need to be also. This
You
will-
seek time in that case, you move your application tomorrow, we'll grant for tomorrow.
Lordship.
Yes.
May it please, my lord. My lord, with respect to item number 17 of the daily list, my lord. Conducting counsel Mr. B. Chaudhary is in bereavement, my lord. I'm praying for adjournment, my lord.
Okay, 15 matter, okay, some bereavement. Okay, have you informed the other side?
Yes, I have a petition.
Okay. 1 week?
My lord.
It is submitted that Sri B. Chaudhary, learned standing counsel, finance and taxation, is under bereavement. Para. In view of the above position, matter is adjourned to be listed after a week.
Interim order that means.
Interim order passed earlier to continue till the next date of listing.
Highly obliged, my lord.
May it please your lordship. Lordship, I beg to mention a fresh writ petition for listing tomorrow, lordship. It pertains to eviction.
I have said my lord for motion, my lord.
Motion tomorrow.
May I please, your lordship, I beg to mention 3 writ petition for listing for admission.
Admission. 3 writ petitions. What
Yes.
is the urgency?
The matter is regarding cancellation of GST registration under the state.
Where is the urgency? There is no urgency.
The case is,
To move, to list by mention memo, there has to be an urgency shown by the council.
my lord, the cases are covered by judgment passed by this honorable court and the same.
Maybe. You make an application to the registry. Next Wednesday.
Thank you, my lord.
Are you sure it's all the 3 are covered?
Yes, my lord.
All the 3? Yes, GST, any council present? State GST or CGST?
GST,
State or central?
state,
State. Which matters, Mr. Gogoi? What is the subject matter, madam? No, she's trying to make a mentions by submitting that these are covered matters. We wanted to know the subject matter involved. She doesn't know. And yet you know these matters are covered.
In fact, my lord, no such matter has been listed today, my lord.
No, not today. She's praying for listing, saying that these are covered matters. That much she knows, nothing more than that. You should come prepared. What is the subject matter?
Yes.
Okay, when is the next?
Thank you, my lord.
Yes,
Paying for a listing of a writ petition, Lordship.
fresh matter.
No, Lordship, motion, yeah, notice has been issued, Lordship.
Then why out of turn listing?
Lordship, it is for non-issuance of NOC for setting up an IMFL off shop, Lordship. Last listed on,
Sorry,
February
sorry.
25, Lordship. Next week, any date, Lordship.
We are maintaining some standards in mention memo. Unless you make out a case of urgency, accept motion will not do. Yes.
My lord, may it please your lordship. My lord, may kindly
Yes.
come to page 60.
Mr. Gogo, you are here?
Google is here.
How come you can't hear it?
Page 60, my lord.
Chandan. Thank you. How many make you go in? If I was number. Yes,
Page 60, my lord.
60.
60.
It was remanded once, isn't it?
No, my lord.
This is the second round.
Second round. First round, your lordship was pleased to, my lord, allow withdrawal and no coercive measure was taken. Page 60 here, your lordship will find this is a so-called notice for cancellation of registration. Whereas on the basis of information which has come to my notice, it appears that your registration is liable to be cancelled for the following reason. My lord, here about cancellation, it doesn't say about prospective or retrospective, my lord. It just says cancel. Cancellation. And the section 29 2E, the provision was quoted. It is a reproduction of, my lord, that section. Now your lordship may kindly come to page 86.
Yes.
Order of cancellation of registration.
Yes.
Here your lordship will see after quoting section 29 2E, reason, without assigning, my lord, how it is fraud, how it is suppression, no material, nothing, my lord. There is no explanation. Here the remarks is, my lord, the effective date of cancellation of your registration is 11/12/2021. It has given, my lord, retrospective effect, whereas in the so-called notice, my lord, it is not there. The same question, my lord, came up before Honorable Delhi High Court, my lord. Delhi High Court has held that, my lord, retrospective, if it is not in so-called notice, retrospective cannot be given, my lord.
Yes.
My lord, I am just placing two decisions, my lord. One is Telangana, another is Delhi. Delhi High Court, my lord. Paragraph 9. Para 9.
You cannot give retrospective effect unless you indicate in the show cause.
This is the law laid down by Honorable Delhi. It is in fact settled law. Para 9 says, my lord.
Yes.
Para 9 says, your lordship has got it.
Yes.
The
Para
second-
9.
Para 9.
Just a minute, please.
Eight and 9 are relevant.
9.
9. The settled legal position is that if the so-called notice does not contemplate.
Yes, we have read this.
And second, your lordship, it is the reproduction of, my lord, section 29. In
To
this context, my Honorable Telangana Division Bench of that I have given your lordship, para 4. para 3, your lordship, whether so-called notice for cancellation of registration and action suspending the registration by order is justifiable and proper or not. The learned counsel for the petition advanced singular point by contending that only so-called region shown in the impugned so-called notice dated so and so is mere reproduction of language of section 29 to E.
You're reading paragraph?
Para 4, my lord, paragraph 4.
Yes,
It is termed the learned counsel for the
Yes,
petition,
yes.
my lord.
please read.
So and so, advanced the singular point by contending that only so-called region shown in the impugned so-called notice dated so and so is mere reproduction of language of section 29 to E of the Central Goods and Services Act and does not contain any necessary details on the extent of which the conclusion has been drawn. Thereafter, my lord, your lordship may skip over and para 8, my lord.
Yes.
Since the so-called notice and suspension of registration is founded upon a critic notice, both are set aside. On regular basis, we are painfully noticing this kind of notices, my lord. This is what observation given, that this is a notice was issued cryptic manner. Here also, my lord, in the so-called notice as well as in the impugned cancellation order, only reproduction of section has been given. And in the cancellation order, my lord, they have given retrospective effect so far as cancellation is concerned. That is not tenable in the eye of law, my lord. And my lord,
Let us see the so called once again.
so-called, my lord, page 60, my lord,
60.
60. So-called notice for cancellation of registration, whereas on the basis of information which has come to my notice, it appears that your registration is liable.
Okay, okay.
My lord.
Yes.
So my humble prayer is, my lord, your lordship may be pleased to issue notice in the entry, my lord, cancellation may be stayed and my lord, respondent number 7 may be directed to release my goods, my lord, trucks, my lord. This is my prayer.
Yes.
No, my lord, so far as my lord, the judgment referred by my learned friend is concerned, lordship, that is factually distinguishing. First, my lord, the Delhi High Court judgment. In that case, my lord, SSC themselves has applied for cancellation of registration, my lord.
No, we are not on that. Leave aside Delhi High Court, leave aside Telangana
My
High
lord,
Court.
my lord. Otherwise,
No
my
court
lord,
notice, there is no, nothing.
my lord, in fact, my lord, this so-called notice was issued, my lord, based on a proceeding initiated by the, my lord, respondent number 4, my lord, respondent number 5,
No,
4, lordship.
He shows cause against what?
My lord, it is specifically stated that the, my lord, the registration was obtained, my lord, by means of fraud.
No. Where?
My lord, page 60, lordship.
Yes. See,
Whereas on the basis of the information which has come to my notice, it appears that your registration is
liable
liable
for
to
the
be
following
complete.
reasons. This is
My lord.
29E.
My lord.
Where is the
Remark,
application?
you, my lord, he didn't file any, my lord, reply to this, my lord. And
No,
in fact,
is this, can this be treated to be a valid show cause notice? He
Hmm.
shows cause against what?
my lord, it is
Where is the
clear.
allegation?
Yes, lordship. Allegation is, my lord, it is obtained by way of fraud, my lord.
No, where is the allegation? You have to,
My
you
lord.
cannot read allegations between the lines. These are rights which is given to them. There may be very good reasons, valid reasons.
My lord.
Disclose, get the reply, cancel it.
Yes, my lord, he has not filed any reply, my lord. The interim order.
What
your
reply to
lordship,
be
is
filed here?
Page 80, my lord. Kindly see, my lord. Page 86.
Did you receive this or not?
Which-
Did you receive this so-called or not?
Yes, my lord.
Did
That was
did you
telling
ask for any reasons?
My lord, during the pendency, I approached this honorable court, during the pendency, they have cancelled it. Accordingly, I have withdrawn it and then filed my notification. During the
You had
pen-
to approach this court.
My lord, I approached this court.
Lord, page 86, lordship.
86.
The order of cancellation of registration.
Yes.
This has reference to the so-called notice issued
Yes.
dated so and so. Whereas no reply to the so-called notice has been submitted, and whereas the undersigned, based on records available with this office, is of the opinion that your registration is liable to be cancelled for the following reasons.
Same as so-called.
See, why do you invite this kind of orders from the court? Once we stay this consequential order maybe for release of the goods, if you have a genuine reason, you may have good reasons.
Lordship.
Disclose this. Get a response. Take action in accordance with law.
Let me file my affidavit, Lord.
Now you'll file your affidavit, but how will it make a difference? He
It should
prays for
be
an
short date may
he
be
prays
fixed.
for an interim order, and court
Well,
emphasize things that
He has been already protected by an interim order.
No, my lord. My goods are there, my lord. and registration.
What
is-
kind of goods?
Two trucks of my lord.
material.
Scrap, my lord.
Okay,
It is-
scrap, not
it is
perishable, not
Not
perishable,
perishable, but from
not
last,
perishable.
Yes.
from last 1.5 month it is there. We are paying rent,
submission.
your lordship.
Though, my lord, the SOCOS has been issued by, my lord, the S104. Lordship will see, my lord, the provision, my lord, section 29 for comment, my lord. Just
29E,
29 2E,
2E, yes, Assam, two, very good.
GST, my lord.
Yes,
Central
yes.
GST.
Now,
Page 39.
page,
39.
yes, please,
Lordship will
29
see-
2E.
Yes. 29 says cancellation or suspension of registration. One says the proper officer may either on his own motion or on an application filed by the registered person or by legal heir, in case of death of such person, cancel the registration in such manner and within such period as may be prescribed having regard to the circumstances. We are concerned with two.
Hmm.
The proper officer
The
may.
statute gives you right to make it retrospective effect.
Yes,
Make use
that's
of
what I want to point out. And Lordship will see E. E. 2E.
is.
Registration has been obtained by means of fraud. So it is there, my lord, implied. And my lord, on top of that, in the SOCOS notice at page 60, Lordship will see the last line. Kindly refer the supportive documents attached for case specific details.
Where are the documents?
My lord, probably
There
yes.
is no document.
Huh?
He has not annexed it, my lord.
No,
No
there is
statement is
no-
there, my lord. Though this particular line is there, no supporting document has been provided.
And my
Where is the
learned fri-
statement, my lord?
My learned friend is appearing for West Bengal, my lord.
No,
Yes,
these
no,
cannot be-
Mr. Goyal, that is not the question.
No,
He's trying
He
to
just
point
yes.
out a point of
My-
law.
my-
Where is your statement? He may be correct. Where is
My
the
lord,
statement that along with this
My-
10/7/2025?
We have not received this, statement is not there, my lord.
Then,
No, that's why we have
We
to
have
fill
not
out-
received.
then.
But the order is
See,
cryptic,
the
my
show
lord.
cause notice may be correct, you may be correct in contending, it doesn't contain any reasons,
that
but
may
if there are enclosures to explain the show cause,
There is no enclosure, that much left, my lord. But that may be by way of additional affidavit, my lord. But my lord,
that we are nobody to advise you. That is what we read, if you are
but it
making
is,
out
my
a
lord,
case
document
that
attached for the
you have
case
not
is
given,
proceeding.
see, ultimately, what is your case? There is principles of violation of natural justice, you are not even afforded the reason on which you will show cause. Now, this appears that there are
But
enclosures.
documents may be, my lord, but there is, the reason given is the reproduction of section 29 2E. There is no.
If the document was given without any enclosures, there was no difficulty on this part to accept your proposition.
My lord.
Now,
No,
it appears that
without
something else is there.
enclosures are not there. This much we have received, my lord, that I have annexed.
Heard, Sri A. Goyal, Learned Counsel for the petitioner. The grievance of the petitioner is against a proceeding initiated by a show cause notice dated 10/7/2025 by the Superintendent IB Range Guwahati Zonal Unit requiring him to show cause as to why his GST registration should not be cancelled. Full stop. The said notice was the subject matter of challenge by the petitioner in WPC 3992 of 2025, which was disposed of by this court by directing, what was the direction?
No corrective measure may be taken. Page 9.
Was it disposed of?
It
It
was
was disposed
disposed.
of, my lord, liberty was granted to file afresh by challenging the impugned order. Lordship.
Okay.
Cancel.
Which
For a
was
particular-
disposed of on the contention that the show cause proceeding had already culminated. Full stop. Liberty was accordingly granted to the petitioner to challenge the cancellation order. Full stop. Accordingly, the cancellation order dated 30/7/2025 is also the subject matter of challenge. Full stop. Para. The Learned Counsel has submitted that the show cause notice is cryptic, and apart from extracting the provisions of the statute, namely section 29 within bracket 2 within bracket E of the CGST Act 2017, no other reasons were disclosed. He has also assailed the cancellation order dated 37/20/25, as per which the cancellation has been given retrospective effect. It is contended that unless such an indication is given in the show cause notice, retrospective effect cannot be granted, cannot be given. Par contra, Sri S. Chetia, the learned, your senior standing counsel
Lordship, I'm for 2 and 3, my lord.
for the
4, my
CGST
lord.
has submitted that the contention advanced on behalf of the petitioners may not be factually correct. By drawing the attention of this court to the show cause notice dated 10/7/2025, he has submitted that the said notice itself was accompanied by enclosures. And there is no statement made in the writ petition that the petitioner did not receive any enclosures. Full stop. Para. Sri B. Gogoi, who has entered appearance for the response numbers
5, 6, 7.
5, 6, and 7, has drawn the attention of this court to the provisions of the statute and has submitted that the statute itself enables for giving retrospective effect to such cancellation order. Full stop. Para.
My lord, one more submission, my lord, regarding the maintainability part, so far as the second prayer is concerned, the seizure was conducted by the officer.
He has also
West Bengal.
raised the issue of maintainability as the seizure was conducted in the state of
West
West
Bengal.
Bengal. Para. Let notice be issued, returnable by 4 weeks. Sri Chetia, the learned senior standing counsel CGST, accepts notice on behalf of
My lord, I am for 2 and 3.
Union of India.
My lord,
Union of India,
Lordship,
your name
and Kakoti Lordship.
on behalf of Diane. Esikal. 1 and 4, 1 and 4, and Kakoti on behalf of Esikal, 1 and 4. Then Chetia for 2,
2 and 3, my lord.
2 and 3, 5, 6, and 7. B. Gogol. Extra copies. 3. Goel, the learned counsel, praised for an interim order and has submitted that a direction may be given for release of the goods. Full stop. The said interim order, said prayer is, however, strenuously opposed by the learned counsel for the respondents. Para. Considering the above, comma, this court is of the opinion that while a blanket interim is the opinion that while an order for release of the goods may not be warranted at this stage, comma, it is submitted, it is directed that no coercive action be taken against the petitioner qua the impugned action till the next returnable date. Full stop. The respondents, contesting respondents may file their affidavit and also produce the relevant records, including the aspect of receipt of the documents enclosed to the show cause notice dated 10/7/2025.
Well, regarding the seizure part also, my lord, record will be necessary or will file.
These are, we are not very
Yes,
concerned.
because that the jurisdiction part is still. Then
See,
we will say, my lord, the
See,
respondent.
both the points, arguments appear to be attractive, but if you can show that he was aware
Yeah.
regarding the action proposed, then
Of course, my lord.
we may not be agreeing with Mr. Goel.
Well, record.
And
will be-
retrospective, you have shown the law.
Yeah.
But only thing still you have to make out a case that if you do not indicate, powers are there with you, that is not disputed.
my lord.
But if, are you required to indicate in the show cause notice that you may also go for a retrospective, is it required?
We will address on.
Well, regarding the record part, it respond number 2 and 3 will
Yes,
produce, my lord.
yes.
That may be indicated, otherwise all respondents, my lord, I will come in, my lord.
No,
Only two
whoever,
and
we only want, who had
On
issued
the
the,
cancellation part.
who had, is under the
Lot,
cancellation.
lot.
part.
My lord, I am praying for a stay of cancellation, my lord, because I can't run my business, my lord, because
No,
of
no, my lord.
cancel-
Otherwise, lordship, my lord,
We'll give a returnable date.
Lordship.
My lord, in fact, section 30 had provided that for application for recalling the cancellation order, my lord. He has not availed it also.
List on today's 28th. List on 1, 2, 3, 4. Last week will be slightly hectic. Can we put on the on a prior date 19th
19th of September.
September?
Right.
Because on the last week it may be hectic
Lordship.
and he has some urgency.
Lord.
19th. The petitioner is also at liberty to avail the remedies under section 30.
30, lord.
30 of the act. And if such an application is filed, the same is directed to be considered in accordance with law.
My
Deeply applies.
deeply.
But we have served the copy, my lord, to Mr. Taluka, he is appearing for the cooperation department.
Yes.
But the point is very simple, my lord, the warrant has been issued. Lord, my humble submission remains that without any providing any copy of the certificate, they will.
Madam, he is not averse to the proceeding.
Lordship,
He is citing some ignorance and he is just praying for some time
Lordship.
and a temporary halt on the warrant.
One.
That is what is. Okay, we'll issue notice of
Lord,
this. to-
bona fide, my lord, I am ready to deposit a, my lord, some amount, my lord, also.
How much is the loan?
Lord, the loan was 4 lakhs. But
4
I
lakhs.
have said in my petition that I have made certain payments, but the problem is, my lord, lordships are.
How much are you going to pay?
Because we'll pay 30,000, my lord, within 2 weeks, my lord, from today.
30,000 is too less.
Because now there is no business, my lord, because everything, my lord, we have said that during the COVID, everything is gone.
You pay, the 50 is also very less. You pay 50,000 within a period of 15 days.
Lordship will then at 40, my lord, because beyond 40 will be difficult. I have taken
50,000,
instruction.
50,000, 15 days. Okay,
Lord, Lordship,
heard,
kindly make it 3 weeks.
heard
weeks.
Sri A. Ganguly, Learned Counsel for the petitioner. Full stop. The grievance raised in this petition is against a proceeding in Bakijai case number so and so, huh? B is likely pending before the certificate officer, Bakijai branch, Kamrup. Full stop. It is the case of the petitioner that he had availed a loan from the respond number 3 bank. What is the name of the bank?
Nagarik Samagam.
Nagarik Samavaya Bank Limited.
Respond number 3 bank, which he had failed to repay, leading to institution of the Bakijai proceeding. Full stop. The Learned Counsel has submitted that he has been making all endeavors to repay the loan and only for reasons beyond his control, comma, the said repayment has not been able to be done. Full stop. Para, let notice be issued, returnable by 4 weeks. Madam, for
1 and 2, your lordship.
3 my lord, notice will have to go.
four commissioner, 1 and 2, walked,
ST.
ST walked, sending council, cooperation department. 3, 4, 3 to be shortly, 4, J. Hendrick State Council, extra copies, 3 registered post with AD. The Sri Ganguly, the Learned Counsel prays for an interim order. He has submitted that if in the meantime the warrant of arrest is executed, comma, irreparable loss and injury will be suffered by him. Para? After he has also undertaken that to show his bona fide, his client is willing to make some deposit. Para? After consideration of the aforesaid submission, it is directed that till the next returnable date, no coercive action pursuant to the Bakijai case number so and so, including execution of the warrant of arrest, be taken against the petitioner, provided subject to the conditions that the petitioner pays an amount of rupees 50,000 within a period of 3 weeks from today. Full stop. The It is however clarified that in the event the petitioner fails to make the aforesaid payment within the time stipulated, the interim order shall not be operative.
Deeply.
Obliged, your lordship.
Mr. Ganguly, you have to file amended cost title.
That liberty
This
may be given. I'll
corporation
file a correct-
department and state field building, don't
Lordship.
make this kind of,
Lordship,
see
that-
how it looks.
That liberty may be.
What is
given,
state
we'll-
field building, what is corporation department,
That is there.
there may be others also.
By Monday, my lords, we'll file a corrected copy. Lordship.
The learned counsel for the petitioner is also given liberty to file amended cost title in correctly describing the department.
Deeply.
Obliged.
May I please, Lordship? So the matter pertaining to the granting of mutation. Now, Lordship, page 87, the views of the learned revenue board is that, my lord, paragraph 9.
You are challenging revenue board's order. Page
Page 87, paragraph 9.
87.
87. 87. Now, Lordship, here it was held, considering the above facts and circumstances and legal position in hand, it can safely be concluded that the applicant will be entitled for mutation of the DL if he is able to get probate certificate as paid before the competent court of concerning the will executed by late Iqbal Kaur, the owner of the land. Now, Lordship, in terms of the section 213, subsection 2 of the Indian Succession in 1925, there is no any necessity for getting probate against the will, except 3 presidency towns, Madras, Bombay, and my lord, Calcutta. This is the one point, my lord. That section is there, my lord.
There is no requirement for
No, my
probate.
lord. For this purpose, my lord, there is a citation also from the Honorable High Court, and also there is a citation from the Honorable Supreme Court to that.
How do you execute an will then?
My lord, the thing is that so far the will is concerned, my lord. The process, this one is a very interesting situation. Suppose I have a will, my lord, then I can apply for mutation. Now, once I apply for mutation, then notice will go to the legal here. If suppose they concede, no problem. But if suppose they dispute, then I have to come back to the civil court under section 34 of the Specific Relief Act, claiming declaration that the will is valid in the eyes of law. That is the law, my lord. But here is a
Let us
case.
see.
Yes, my lord. No, Lord, just have a look for a moment. The section 213, subsection.
Let us see the exposition of the law.
Yes, my lord.
We have not come across this law.
Yes, my lord. This is a new zone, my lord.
Whether it is there, but it is not unqualified for
Let-
Hindu,
let me
Sikhs.
complete, let me complete. Now, Lordship, section 213, there are 2 provisions.
213 of the,
Indian Succession Act 1925.
now even if we accept your proposition,
Well,
did you go for mutation on the basis of the will?
my lord, this is the score issue that has been disputed by the other side, and
Then if it
appellate-
is disputed, then what do you do?
my lord, in that situation, because my properties case is pending, no doubt. But here is a case, my lord, because revenue board has taken consideration that because property is necessary until, my lord, mutation cannot be effected. But it escaped the law that 213 subsection 2
No,
doesn't demand.
so ultimately it boils down, if there is a probate case,
My lord,
and if it is contested,
my lord,
that means
Well-
there are disputes.
my lord. No doubt, my lord, but it is not
So
a,
if it is not, if there are no disputes,
Yes.
matter would have been different.
my lord,
Now,
but-
once you said that the probate case is contested,
Well-
and there is a dispute,
my lord.
then unless there is a probate of the will,
My
how
kindly-
do you execute?
213, my lord.
213.
Page 67. There are 2 provisions.
Yes, please.
Right as executor or legatee when established.
Hmm.
No right as executor or legatee can be established in any court of justice unless a court of competent jurisdiction in India has granted probate of will under which the right is claimed, or has granted letter of administration with the will or with a copy of an authenticated copy of the will annexed.
Hmm.
Subsection 2. The section shall not apply in the case of wills and made by the Mohammedans, Indian constitution, and shall only apply in case of will made by the Hindu, Buddhist, Sikh, Jaina, where such a will are classified, specified in clause 1B of the section 57. Subsection 2. In a case of will made by any Parsi dying, the commencement of the Indian Succession Amendment Act, where such will are made within the local limits of the ordinary original civil jurisdiction of the High Court of Calcutta, Madras, and Bombay, and where such wills are made outside those limits insofar as they relate to the amount of property situated within those limits, my lord.
Yes.
Therefore, my lord, in these terms, my lord, the Honorable Supreme Court and our Honorable Guwahati High Court also consider this aspect of 213 subsection 2.
Let us see.
My lord. Now, Lordship, first citations is my lord, this is the
Now,
citation.
first, let us understand what is the meaning of 213 subsection 2.
Subsection 2, my lord, basically it considered in respect of 3, my lord, presidency town, because it's a British law at that point of time.
No, first, this section shall not apply in the case of wills made by Mohammedans or
This is
Indian
one clause, my
Christians.
lord.
That is one.
One.
Or, and shall only apply. Where it will apply?
My lord, subsection 2.
And shall only apply in the case of wills made by Hindu,
Hmm.
Buddhist,
Yes,
so-and-so, or classes so-and-so. This will not help you.
yes, my lord.
In the case of wills made by so-and-so after the commencement,
Within the local limits of High Court of Calcutta, Madras, and Bombay. Even also, we were not that point of time by the part of my lord Bengal.
ordinary
Now,
original
can you see the
civil
citations?
jurisdiction. Permit entry local limits.
My lord, section, my lord, paragraph 7, the citation is Samar Krishna Saha.
Outside those remain so forth. And what about the last part? And where such wills are made outside those limits.
Yes,
Insofar as they relate to immovable property situated within those limits.
my lord.
What is the nature of the property?
My lord, the immobile property, suppose if suppose outside of that three, my lord, presidency town, my lord, then my lord, this will not apply, my lord. That is the basic, that has been discovered on Guwahati High Court.
So this will apply.
Yes, my lord.
This will apply, not apply.
Will apply, but probate is not
No,
necessary.
no. Come to subsection 2.
My lord, in case of will made by any Parsi, dying after the commencement of the Indian Succession Act, where such will are made within the local limits of the ordinary civil jurisdiction of the High
So
Court.
for a Parsi, it will apply after commencement, where such wills
was-
are made within the local limits of.
It was by way of amendment, it was brought into record by 1962 afterward. Parsi was also included.
Yes.
But other than my lord, that High Court of Calcutta, Madras, and Bombay, and where will are made outside those limits. In so
No,
far as
is two is for whom?
my lord,
Subsection 2 is for whom?
2 is for my lord, for the purpose that there are two phases, my lord. One is that
No,
96.
Subsection 2 is for who? Which
My lord,
community?
it will applicable in 3 presidency
No,
towns.
which community?
My community, my lord, earlier that all community was that Parsi was also included after
No.
1962.
Please read again.
My lord.
In the case of wills made by any Parsi,
Dying. Earlier
dying.
it was not there.
See, it is only for a Parsi.
No, my lord. My lord, subject to lordship correction. My lord, clause 1 can indicates about my lord that religion, my lord. Now, 2, my lord, 1962 also brought on record that Parsi party is also there.
Yes.
Afterward, lordship, we are relevant
Yes.
part. That 3 town, that is Calcutta, Madras, and Bombay, this will apply. Probate.
For a Parsi.
But Parsi was afterward in earlier they protested that they should also be the part of
So
that.
see, there are 2 subsections in, there are 2 subclause in subsection 2.
Yes, ma'am, no doubt.
First one says that, let us read again 213.
Yes,
No right as executor or legatee
yes,
can be established in any court of justice unless
Yes.
a court of competent jurisdiction in India has granted probate of a will under which the right is claimed or
Claimed.
granted so and so.
yes,
So the requirement of probate is stated in
Yes.
first.
quite.
Then what is number 2?
2 is about
Section-
that this will not apply. This is 2
Sections shall
class.
not apply in
Two
cases
classes
of
there.
wills made by Mohammedans
Yes.
or-
yeah.
Indian Christians.
yes.
Matter ends there. Or
And then apply
and shall only apply. Whom it
Apply.
will apply?
this community.
First is Hindu, Buddhist, Sikh, Jain,
Yes,
where wills are of the classes so and so.
Yes.
Second is a Parsi, where it is within the 3 local limits of the 3
yes, ma'am.
presidency town. Now, it
Right.
comes under, you come under which category?
My lord, I come under the category of 213 subclause 2, my lord.
Are you a Parsi?
No, no, I'm not Parsi, I'm Hindu, there is no problem. One is applicable,
I think-
but so far these three states,
Those three presidency high courts are only for Parsis.
No, my lord, if lordship kindly see the my lord, on all high court judgment and supreme court lordship, this has been classic, my lord, that has
Let
been
us see, let us see.
my lord, my lord. Lordship first is my lord Samar Krishna Saha, lordship has got it honorable high court judgment
Yes, yes.
2006.
Yes.
Now lordship, the same issue has been brought on that has been dealt with. Paragraph 7 lordship mechanism for a moment. Now lordship paragraph start from paragraph 6, my lord. The 213 part is there.
Paragraph 6.
6, my lord. Married, my lord.
Yes, please.
Coupled with the above, it is also necessary to point out that it is section 213 of the Indian Succession Act which makes it obligatory for the executor legatee of a will to obtain probate of the will before he or she claim rights based on the will. For the sake of the brevity, section 213 is quoted here. This is already we have discussed now, Lordship. Paragraph 7. A careful reading of the provision section 213 would indicate that an executor or legatee under a will has to obtain probate of the will wherein he claim his right, provided that his rights are claimed in a court of justice. In other words, if a person who is an executor legatee under a will does not claim his right under a will in a court of justice, he is not required to obtain probate of the will under which he claimed the right. This apart as indicated under subsection 1 of section 213, the requirement to obtain probate lies only where the will is made by Hindu, Buddhist, Sikh, Jain, when will are classes specified in clause A and B of section 57 of the Indian Succession Act. What also need to be pointed out is that the clause A and B of section 50 indicate that these provisions are applicable to all the will and codicils made by the Buddhist, Sikh or Jain within the territories mentioned in clause A, and also to such will and codicil where, though the will and codicils are made outside the territories mentioned in clause A, the immovable property is located within the territories of the limit of the specified clause A. A combined reading of section clause A, B of the section 57 and also section 213 would show that where the party to the will are Hindu, but the property is not situated in Bengal, Bombay, and Madras, subsection 2 of section of the Indian Succession has no application. It therefore logically follows that probate will not be required to be obtained by a Hindu in respect of will made regarding the immovable property situated in the state of Tripura, for the state of Tripura has admittedly never been the part of erstwhile state of Bengal. In the passing, it may also be indicated that section 213 is applicable only where a person claims his right as an executor of legatee under a will and not when he claims his right in any other capacity. In present case, though the said disease was a Hindu, the fact remains that the immovable property left by him is in Isna Chandra Nagar, where it did not fall within the erstwhile state of the Bengal, and hence probate could not have been insisted upon when the petitioner has applied for mutation of the land as a beneficiary under the said will. What crystallized from the above discussion is that the mutation application of the petition has to be considered and necessary order has to be passed in this regard by the respondent number 3, who is the competent authority to grant mutation, and that for the purpose of claiming mutation in respect to the property in question, it is not incumbent on the part of the petitioner to obtain probate of will wherein he has made a claim for mutation. Bearing in mind the above aspect of the matter, respondent number 3 is required to dispose of the application for mutation in question in accordance with the in result for the following the read petition disposal with so and so direction. Now, let's see another citation on our Supreme Court. This has been numbers of recited, my lord.
Paragraph 8. Paragraph 8.
My lord, paragraph 8, my lord.
Let us see.
My lord, this has also been discussed. My lordship, I have pointed out middle part, the effect of section 213. Red mark I have given, my lord. Now, so far, my lord, this clearance, pace, and union, this has been cited in numbers of citations also, my lord. My lord, middle part. Advanced same discussion. Let's see. 2001 4 SCC 325.
The Samar Krishna has taken into consideration the Supreme Court.
Yes, madam. Samar Krishna. My lord, so far, yes, my lord.
Clearance space.
My lord, lordship, Samar Krishna's case, my lord.
Tamar Krishna has,
My lord, it has, my lord, the power of.
Tamar Krishna was decided when?
My lord,
2006,
2001.
Supreme Court in 2001.
Yes, and this is afterward, my lord.
Combined reading of.
Samar Krishna case. Samar Krishna's case perhaps not discussed, my lord. But in other cases, my lord, it has been referred, my lord. And one citation, if lordship please to see Gujarat, that was afterward, see a similar situation. I have citations.
Okay,
Now, lordship, paragraph 8, middle part,
yes.
2001 judgment,
Yes.
Clarence Payes versus Union of India. Lordship, the same thing has been dealt with, and middle part, lordship, may kindly be seen. Red mark. A combined reading of sections 213 and 56 would show that where the parties to the will are Hindu or property dispute are not in territories falling under section 57A and B, subsection 2 of the section 213 of the Act applies, and subsection 1 has no application. As a consequence, a probate will not be required to be obtained by Hindu in respect of will made outside those territories or regarding the immovable property situated outside those territories. The result is that the contention put forth on behalf of the petitioner that section 213 is applicable only to the Christians and not to the other religion is not correct. But that was dealt with in different community. Now, similar situation where that has been dealt with number of citation. If lordship please, then I can solve them. Now, lordship, the second limb of my submission is that, my lord. My lord, we have agitated one point before the learned revenue board that the appeal which was preferred by the other side challenging my mutation that was affected by a flaw of limitation. Now, lordship, in terms of section 148 land revenue regulation 1886, there is a limitation that has been prescribed 60 days, my lord. My lord, without, my lord, affecting the of limitation part, my lord, straightway the order was passed. That issue that we have agitated, but that was not considered, my lord. Therefore, two legal points are there, my lord, which require consideration of this one. First is that 213 subsection 2 of the Indian Succession Act. And second thing is that, my lord, once there is a prescription that 148 is applicable, therefore, revenue board has, though lordship we have taken the ground, lordship just look for a moment, page 74. Paragraph 6 and 7, specifically we have pleaded.
74.
Yes, page 74 of my appeal memo, my lord. There is no any, my lord, answer to that effect. My lord, page 74, paragraph 6.
Yes.
My lord, has we raised the issue, the impugn order dated 14/9/2016 passed in so-and-so is bad in law, illegal, arbitrary, himself, barred by limitation, apart from the without giving any opportunity to applicant, respondent, file objection, etc. This is one point. Second, that the order of mutation dated 29/9/2014 by the Circle Office in mutation case number so-and-so was challenged in appeal before the additional deputy commissioner, being number as so-and-so, which is barred by limitation. My lord, further, no application to condone the delay has been preferred. My lord, on this point also, there is a citation from the Honorable Guwahati High Court says that limitation cannot be bypassed. Because, my lord, otherwise, lordship kindly see that 2014 order was put under challenge in 2016, my lord. It's not a, my lord, ordinary delay. 2 years has elapsed, my lord. Therefore, these are two legal points required consideration of this honorable court principally, my lord. My prayer that lordship admit this, my lord, petition.
This is for hearing, isn't it?
Yes, my lord, the required hearing, my lord. We will show some more citation on this point,
No,
my
there's
lord.
no, we are having it for final disposal.
Today, my lord.
Yes, 18 matters.
Otherwise, my lord, no problem, my lord. These are two legal points, my lord, basically. Because, my lord, prima facie lordship kindly see the impugn order nowhere discussed a single line that appeal which was prepared at the, my lord, the first appellate forum, that was, my lord, suffering from the limitation. And we raised this issue, my lord, vehemently. But there is not a single whisper, my lord, in the impugn order. If see, my lord,
The impugn order before the board.
board, my lord. My lord,
And what is the answer of the board?
answer the board that center on probate, my lord.
No, on this point of limitation,
Limitation, there is no discussion.
there is no discussion.
And otherwise, lordship kindly suppose we didn't take the point. But my lord, second forum at least see that if suppose, because merit of the case doesn't matter that, but question is that if suppose legal formality is, my lord, bypassed, that is the basic requirement to be, my lord, tested by that, my lord, second forum. Instead of, my lord, going to the, my lord, the discrete inquiry, etc. Now question is that the probate, otherwise, my lord, the probate debt has been raised at point of time, my lord. A revenue board dealt with this kind of matter similar numbers of time, my lord. They know that 213 is the effect, my lord.
Yes, Mr. Chaudhary.
My lord, first and foremost, the question of probate may not arise here because this is purely on the basis of mutation which was granted by the by a revenue authority. Irrespective of the fact, both these citations state that the territories which are outside the control of the Governor General of Bengal or the High Court of Judicature of Calcutta, Madras, or Bengal, only in those territories probate may not be necessary. Even in Samar Kumar Saha's case, it is said that the property is situated in the state of Tripura and hence probate may not be required. The same is in the case of Clarence Pies, where the property was situated in the state of Uttar Pradesh. So these may not align with my learned friend's submission that no probate is necessary. Probate is, as per section 213, probate is not necessary only in case of Mohammedans and Christians. However, in case of Hindus, Buddhists, Sikhs, and Jains, there is a qualification as per section 57, clause A and B. I would not delve much into that aspect. Rather, a probate was also preferred by the writ petitioners before, and that probate was also dismissed, my lord.
That case has been dismissed.
That case has been dismissed, my lord. I have a copy of that. A review is pending at present before the learned additional sessions judge. It was dismissed in the year 2023 on a technical ground of not providing the original will before the probate court.
Mr. Chamaria, your doors are not closed forever. There is a window still given to you.
Yeah.
If you are successful in the probate case, you can,
My lord, the lordship may point out one.
on the aspect of requirement or not, yeah, you have made your submission, we'll consider. But the observation is that once, depending on your probate case, you can re-agitate the matter.
My lord, lordship
And
may,
Mr. Chaudhary has said that initially it was dismissed on a technical ground. Now we have filed a review.
My lord, the
my lord,
petitioners have filed a
lordship may
review.
point out one thing, my lord. Can you see that two segments are different, my lord? So for this, my lord, mutation is only for the purpose of paying revenue. It doesn't confirm any rights and ownership, etc., my lord. So therefore, the basic purpose of that supposed to inclusion of my name for different purposes. Now, probate, suppose I have preferred, no doubt, my lord. But suppose it will grant or not grant, my lord. Suppose take it for a moment that it was not granted in my favor, or it has been dismissed, whatever. No doubt, my lord, it will. They can go back and to say that mutation to be cancelled, like that situation. But at first instance, we are on centered point that because lordship now only exercise my revisionary power, principally, my lord, that the order which is now passed by the revenue board is suffering from any legal infirmities, no. If suppose that effect is there, my lord, on the face of that order, my lord, then lordship will not go to the my disputed facts or other facts. Simple, my legal point is that 213, that observation lordship can see for a moment. What is there? Now, if suppose this is outright not sustained in the eyes of law, lordship may interfere definitely. Kindly see the what line, paragraph line. Considering the above facts and circumstances and legal position, lordship, this is the misinterpretation, legal position. In hand, it can be safely concluded that the applicant will be entitled to mutation of the year if he is able to get over. That means he made out his mind that it is a legal requirement, madam. But par contra, madam, kindly see the situation is something else, madam.
Your appeal before the Assam Board of Revenue
Madam.
was against an order of 29-9,
16, madam.
29-9-14,
16, madam. Because, madam, first mutation order, thereafter,
29-9-14, I think.
madam, 14 is the mutation granted in
Yes.
favor.
Yes,
Thereafter, mutation, my lord, that was put on the channel by first appeal, one under section 147.
okay.
That was, my lord, dismissed, against which I prepared appeal, madam.
Oh, you said that appeal was barred by time.
Absolutely. They have preferred appeal, my lord, challenging my mutation at first, my lord, round of. Now, lordship, can you see the line is very questionable that second and legal position in hand, my lord. That means the learned revenue board has applied its legal mind, saying that this is the legal requirement. Now, otherwise also, lordship, that it is a legal requirement. It is required that under which legal requirement this is necessary. This point is missing here. Lordship only see prima facie that whether this order is in accordance with law or contrary to the law. If law says something else, my lord, lordship interference is called for.
My lord, if I am allowed to submit.
Just one, record has been given. Was records called for?
Lordship, I pass record, my lord.
We'll do one thing.
My lord.
We'll have this on a different date. In the meantime, we'll call for the records and we'll have a detailed hearing. We have heard, we have understood the matter.
But it's a very interesting, earlier we also filed numbers of probate cases, my lord, but
Yeah.
it is something else, my lord.
My lord, if I'm allowed to clarify just a small portion.
Yes.
My lord, actually the property originally belonged to one M. Lal Singh. His thereafter, my lord, that.
No, factual part, we may not be too much interested now. We are more interested in 213. See,
Only legal.
the
My lord,
subsection.
anyway, the doors have not been closed. What has been
Yes,
said is
no, that is okay. No, subsection, can come to 213, please.
213, my lord, if I am allowed to.
213, this subsection 2 was inserted later, 1962.
Yes, my lord.
Now, again, there was another amendment whereby Indian Christians were inserted by an amendment of 2002.
Yes, my lord.
But the subclauses 1 and 2 of subsection 2 were in the original amendment.
Yes, my lord.
So why is there a requirement of 2 subclauses?
My lord, because.
No, just
I'm sorry.
listen. If first subclause is that in case of wills made by so-and-so, 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 where such wills are of the classes specified in A and B of section 57. So A and B of section 57 is confined to wills made by Hindu, Buddhist, Sikh or Jain. And there is a different subclause.
They have been expanded, my lord.
And no, expanded, no, not separately.
No, my lord, only community has been.
No, it's not separate. It was the same original
Same,
amendment.
Yes. But
Original amendment itself thought Parsis to be in a different community.
Different.
What will happen to the Parsi community? In the case of wills made by any Parsi dying after the commencement of the Indian Succession Amendment Act of 1962, after the Amendment Act, where such wills are made within the local limits of the ordinary jurisdiction so-and-so, so-and-so, and where such wills are made outside the so-and-so. Now, the case of Samar has read the second part of subclause 2 to be a universal, general part for both 1 and 2. We would like to have your feedback on this.
Lordship, so far the Christian part is concerned, Lordship, we just allow that so far this 2001 Supreme Court judgment is concerned, that has been discussed in length, my lord.
No, we are not on the Christian
Yes.
part. We are only on the part whereby in subclause 2 of subsection 2, there is a requirement, there are other further qualification regarding the original civil jurisdiction of the high courts of so-and-so, so-and-so.
Yes.
This will be for whom? This will be for both 1 and 2 or only for 2 where Parsis are specifically mentioned?
We'll see, my lord, that part.
No, in that regard, if I am allowed to. My lord, subclause 1 of 213 unequivocally states that a will in general is to be, a probate of a will in general is to be obtained. Now that is qualified by subsection 2.
Yes.
In subsection 2, unqualified exception is provided to the Mohammedan and Indian Christian community.
Yes, they are not required.
They are not
Not
required.
required.
And qualified exception is provided in respect of first the Hindus, Buddhists, Sikhs and Jains under one block and for the Parsis under another block. So those are the qualifications, my lord, in which cases this section may apply in case of these community, these
Yes,
two
yes,
blocks of
yes.
community. My lord, if comes to section 57, what does clauses A and B state, my lord?
Yes.
The provision of this part, which are set out in Schedule 3, shall, subject to the restrictions and modifications specified therein, apply to all wills and codicils, any Hindu, Buddhist, Sikh, or Jain, or on or after the first day of September 1870, within the territories which at the said date were subject to the Lieutenant Governor of Bengal or within the local limits of the ordinary civil jurisdiction of the High Courts of Judicature at Madras and Bombay, and to such wills and codicils made outside these territories and limits so far as relates to immovable property situate within those territories or limits. Well, the territories are only given within which probate of wills may be necessary, probate of wills shall be necessary. And apart from that, there are exceptions. That is the case why in Samar Krishna Roy's case, it was specifically held by this honorable court that
State of
the
Tripura.
that the property is in Tripura, my lord.
Yes, yes.
Here, the question is whether the properties were under the Lieutenant Governor of Bengal. After the Treaty of Yandabu ending the first Indo-Burmese War in 1826, the annexation was Assam was made into the British territory. Thereafter, initially it was under, if I'm not mistaken, one of the administrators of Governor General of Bengal. Thereafter, it came under this special control of Bengal, and thereafter it again came under the control of the civil judicature of High Court at Calcutta.
Yes.
And therefore, probate in such case, in my humble submission, would be necessary for these communities in the state of in the areas governed by Section 57A and B. Therefore,
Okay, we'll discuss this.
We'll also see, right?
Heard Re H. Chamaria, learned counsel for the petitioner, also heard Re N. Chaudhary, learned counsel for the respondent, learned counsel for the contesting respondent number 5. Para. Admit for hearing. Call for the records from the learned ABR Assam. Para. Since this matter is pending since the year 2018, list for hearing immediately on the reopening of the autumn vacation.
Interim order is there, my lord.
Interim order passed earlier to continue till the next date of listing. Interesting
Until
stuff.
final disposal, otherwise I can be extension is proceed, please.
We'll have it and
after Puja, after, my lord, is a date fixed?
you can, we have said immediately on the reopening.
Yeah.
Very, very well, my lord.
We can have it on 14th. 13th we are reopening, 14th we can have 1/4.
14 October.
Can it be on 16th? 16th.
16th is also okay for us. 16th,
Yes, ma'am.
list for hearing on 16th of October. Registry to ensure that the records are transmitted by the learned ABR.
My,
Interim order बाद में कितना दो बार लिखना जरूरी है मैं देख लूँ
Yeah, with your lordship. Yeah, and
Ten number?
yes, to my lord.
Yes.
Okay. I'm waiting for response number 1, though we have filed our affidavit. I pray some time till Tuesday, my lord.
What is the matter, Mr. Sahara?
The land acquisition compensation has not been legal, and one land, my lord, actually they wanted to take tax change. That has not been done.
Acquisition for what? Widening of road.
For
GMC.
construction medical college. my lord.
Long back, my lord, 89, since 89. No rental compensation.
Okay, Tuesday next.
Tuesday next, my lord.
Tuesday next. Okay.
My lord, they have to file the affidavit because.
They have filed
Yes,
affidavit.
I'm not denying it. I filed the affidavit, but I have to go through it, my lord. Some clarification.
Some
is
more
needed, my lord.
affidavit is required.
My lord, because they said, my lord, that my name has been stuck up on the basis of, my lord, the settlement deed. But there is no settlement deed, my lord, that deed referred to is a sell deed, some.
Madam, would you like to file additional affidavit?
Yes.
There is an observation on 21/5.
Yes, 21/5, my lord.
If you'd like to file,
In
Then-
view of our affidavit.
Sometime.
and otherwise, not 21 matter, we cannot give you time, only, we can fix it after 1 week. But you have to file your additional affidavit before that.
My lord.
Mr. Sayola,
Yes.
heard Sri E. N. Sayola, learned senior counsel. Para. Ms. P. R. Mohanto, learned standing counsel revenue, has however submitted that though an additional affidavit was supposed to be filed, comma, some more time would be required. Full stop. Para, considering the efforts in prayer and also the fact that the writ petition is pending since the year 2021, a week's time is granted to file additional affidavit. Full stop. List on,
9th, my lord.
okay, list on, we'll have it on 9th, you get more time. 9th,
My lord.
Much.
9th of September.
God bless.
May I please your
In this case, Lordship, we are filing reply affidavit against the affidavit in question filed by the respondent number 7.
7, when did they file? Long time back.
Today, Lord.
No,
today.
7, when did they file the affidavit in opposition? Which year?
No, this is recently, Lordship.
Or recently?
Recently, Lordship.
Okay, let them file them. You have filed affidavit? Or
Yes,
you are 7. And Madam for?
I have, for respondent number 3 and 4,
You have filed affidavit?
only a affidavit stating some facts.
Uh, Though affidavit in opposition, though the pleadings have more or less been exchanged, comma, the learned counsel for the petitioner has submitted that the respondent number 7 has filed the affidavit in opposition recently on 23/7/2025. Full stop. He has informed that during the course of the day, a rejoinder affidavit would be filed. Para? Let such affidavit be, let this matter accordingly stand adjourned to be listed next week along with the rejoinder affidavit that may be filed during the course of the day.
Lordship,
What is the matter?
Lord, our grievance is respondent number 7, Lordship. Initially, we were appointed as Montri Hansalak of Assam Rajya Sabha Prasar Committee.
Appointed as?
As Montri Hansalak, Lordship, that is called direct role, the chairperson.
Okay.
And the.
And you are Mr. Ganguly, 7, who is 7? You have been newly appointed.
Earlier, he
claimed, Your Lordship, as Mantri Sansala. They also claim to be Mantri Sansala.
Both. And who are you? You
And
also
Your
claim.
Lordship, so far as my client says, he is the respondent number 4, Your Lordship, Pradhan Mantri, or something like that, Your Lordship, and her client says that
Who is bigger, Pradhan Mantri or Mantri Prachalak?
Pradhan Mantri is big.
Pradhan Mantri.
Two different idea.
And madam,
Lordship, I am
He-
for the
our
respondent
client
2 and
claims that-
3 and 4, because
you are the
I am,
Mantri.
that is
That is also a disputed.
No, Lordship. That is not disputed, already settled by the charity commissioner.
You approach
No,
Mr.
No, Lordship.
Charity
File
commissioner,
affidavit, we have-
Your Lordship,
We have
take it
the
up next
document,
week.
Lordship, we annex it.
Yes, let them
Charity
file.
commission, Lordship,
Okay.
approve our committee, Lordship.
Okay, both of you approach Mr. Borthakur.
Let them,
He is the Pradhan, he'll solve, he'll resolve.
Lordship, the petitioner may
I
be
just
direct,
trouble the court with these matters.
Lordship, petitioner may be directed to serve the copy to us.
Yes.
also.
Lord,
Yes, please serve copies. Okay.
Deeply obliged.
Date may be fixed, Lordship,
You tell us, we said next week.
next week.
Next week, if you want a date, we can give you a date, no problem at all. On 4th? 4th is a Thursday?
Yes,
Okay, 4th.
yes.
Next month. Fourth bulletin. Yes, Mr. Das.
No communication with the petitioner.
Okay, we'll close this then.
Lordships.
We, be thus learned counsel for the learned counsel has submitted that in spite of their best efforts, there is no contact with the petitioner. Full stop. Also heard Sri R. Sharma learned counsel for the contesting respondent number 7, whereas Miss H. Barua learned counsel is present for the GMC.
GMC and GMD.
GMD. Your state is also there? Sri J. Hendik is present for the state respondents. Para. On the last occasion, that is 28/20/25, Bisat, this court had observed that in case the situation persists, this court would have no other option but to proceed with the case. But to pass appropriate orders. Para. It appears that the petitioner is not keen to pursue this case. Accordingly, the same is dismissed for non-prosecution.
Five lordships. This matter will come up on the next week. In the meantime, I will file my additional affidavit, Lord.
Additional affidavit for,
For my lord, bring us some documents, lordship. It was not brought in the record.
madam,
Lordship, I have a grievance. I will have to express my grievance since for the last 3 days they have been taking time. And Lordship, there was an interim order which was violated, because of which we have already filed a contempt case in this matter.
let them file, madam.
Lordship, in consonance with that interim order, Lordship, I would pray, your Lordship, that there may be a direction that digging may be stopped for the time being, so that logical conclusion could be reached, Lordship. Otherwise, the matter would be infructuous.
How much time?
Lordship, by tomorrow, I can file it. My lord, it is.
We'll have this on Wednesday next.
Lordship.
Okay. Three, J. Hendik, Learned State Council submits that the additional affidavit is almost ready and would be filed shortly. Para. Ms. Begum, Learned Council for the petitioner has, however, objected to the aforesaid prayer for adjournment by submitting that on various earlier occasions, time was taken for filing such additional affidavit, which has not been done till now. She has also alleged that the interim protection granted by this court has been violated, for which a contempt case has been filed. Para? Be that as it may, let such additional affidavit be filed within filed.
By
And the
tomorrow, I can file it.
Filed, and the matter be listed for consideration on Wednesday next.
Lordship, if it could be recorded that on by Wednesday, if they don't file it, the
As a last chance,
Lordship.
as a last chance.
much of it.
Wednesday on my lord, 3rd.
3rd of September. Election.
I am appealing for response number 7, madam. No, I need some time to file affidavit, madam.
What is this, Mr. Biswas?
Lordship, this is against an order passed by the Accountability Committee. Without hearing me, my complaint has been disposed of. And we are agreed.
Which accountability committee? SPAC,
This,
State Police,
Police account.
State Police.
And,
You are for the SPAC,
No, madam.
Yeah, for the-
The inside of the Udalbaga outpost, madam.
against whom the complaint was filed.
Yes.
Okay, and who is for SPAC?
Government, madam.
You will appear.
On the last occasion, they were directed.
What is your grievance?
Grievance, what has happened if your lordship.
You had
come-
made a complaint against Mr. Watakur.
Yes.
Then
Then suddenly we have come to know that it was disposed of, because without even giving us an opportunity to plead before the committee.
okay, you could not even, you were not even
nothing,
heard.
nothing. So,
What kind of allegation?
your lordship may kindly come to page 130. Because there is a civil dispute going on between the petitioner and a builder. Now, annexure IA, page 130. And the relevant portion, which is directly related to the private respondent number 7, starts from page 133, para 8, your lordship.
Who is the complaint, who is the, against whom was the complaint made?
Pritham Das,
Response number
respondent number 7 and
7.
and 8 is also there. respondent number
Subsequently
8 is
impleted. Subsequently impleted or what?
Yes,
7,
Huh?
episode close, madam.
In the original petition, there was no response number
Yeah.
7.
first title we had amended, your lordship.
Well, you don't make him the complaint, the party initially.
Yes, on the first day, this honorable court had directed me to file an amended application, first title, which was
Okay.
filed thereafter.
You file your affidavit then, okay.
Actually, from both the side, madam, there is a FIR, madam. In FIR filed by the petitioner, madam, this charges is in file, madam. And for keeping peace and tranquility,
Now,
madam,
see, Mr. Botawood, there will be two aspects. One is the allegation which Mr.
yes, madam.
Biswas is making, that he was not given a proper opportunity to
Yes, sir.
explain his case. And the
That's what I cannot say,
second is
Yes, ma'am.
the substantial justice.
Yes, ma'am.
Whether by giving an opportunity, some material change could have been made in the decision-making process.
Yes, obviously, ma'am.
We are, there is nothing to dispute that one is entitled to have
Yes,
an
ma'am.
opportunity.
Yes, ma'am.
But if that opportunity will not make any change,
With
then
the
it might
final outcome.
also, it might amount to an useless formality
That,
theory.
that part, ma'am, I cannot say, Milord.
So therefore we want to know what is the nature of the allegation, counter allegation.
Yes.
Okay.
Because he is a third party to the dispute which I have with the others.
Heard Sri A. Biswas, learned counsel for the petitioner. Also heard Sri N. Goswami, learned state counsel para. Sri S. Bothakur, learned counsel for the respondent number 7.
Yes.
Raised for, and is granted 2 weeks time to file affidavit. 2 weeks enough?
After 3 weeks, ma'am.
3 weeks time to file affidavit in opposition. Please talk to 3 weeks. 25 matter.
Yes,
25.
yes.
Lordship, in this matter, senior counsel, Mr. Ken Chaudhary is appearing. Lordship may pass over for the time being, he is on legs now.
Well,
Lordship, after something.
well, there's some urgency, madam, because the contract will end by 30th of May.
Okay, after some time. Thank you. Thank you. Nine.
Lordship. Also, here petitioner has challenged the impugn notice of eviction, Lordship. That asking them to, Lordship, evict from the lands they have been, they are residing there for the last 45 years, Lordship.
Yes, what is your case?
Yes, Lordship. Lordship, that here, it is 2 petitioners are here.
Two
Both-
petitioners.
2 petitioners, Lordship, both are the landless flood affected people of, Lordship, the people of Lakhimpur district, Lordship. So, Lordship, they are, Lordship, occupying a land, Lordship, since 1980. And they have been paying revenue also, and their name has been already been,
Revenue means?
revenue means Khazana, Lordship, that is.
That is not Khazana, that can be Tozi, right?
Tozi at page 10. Page 10, Lordship. The main, Lordship, contention is that the notice which has been issued is not maintainable.
Note, where is the notice?
It's a page 24,
24.
Lordship. This is the simple issue. Page 24 is the vernacular. May I read it?
Yes, please.
Lordship, yes. চক্ৰ বিষয়ৰ কাৰ্যালয় ঢকুৱাখানা ডেটেড 22/22/2014 Lordship, ইয়াৰ দ্বাৰা আপোনাক the petitioner sir at respond serial number 7. Serial number 7 is the Dulal Gogoi. ইয়াৰ দ্বাৰা আপোনালোকক জনোৱা যায় যে ঢকুৱাখানা মৌজাৰ 5 নং লাটৰ মহঘুলি মেপৰ 195 নং দাগৰ ইণ্ডাষ্ট্ৰিয়েল ট্ৰেইনিং ইনষ্টিটিউচন ITI নামত থকা মাটি অবৈধভাৱে বেদখল কৰি আছে। উক্ত বেদখল এই জাননী পোৱাত 8 দিনৰ ভিতৰত বেদখল জমি মুক্ত কৰি দিবলৈ লিখিতভাৱে নিৰ্দেশ দিয়া হ'ল। অন্যথায় আইনগতভাৱে দখল জমিৰ বলপূৰ্বকভাৱে উচ্ছেদ কৰা হ'ব। ভূমিলক্ষ্য নিয়মাৱলী 18(2) ধাৰাৰ মতে। So the section is 18(2), Lordship. Now, Lordship may come to the 18(2). It says that the eviction may be directed when it is a person occupies a government land or the grazing field or, Lordship, that those are of government land, basically. Here they are stating that their land belongs to ITI.
not a grazing field or nothing else. So-
ITI land is not government land.
No, not government, that is, Lordship may come to 18, to section 18.
ITI land is not government land.
It is for ITI only, Lordship. It's on Indian name.
ITI is not a government institution.
Government institution is there, Lordship.
So
But it's not a grazing, field. It's
it's
in the
not,
name of
it's not confined to grazing. 18 to,
government also.
yes,
Otherwise, also, it's specifically it says that it's ITI land.
yes.
So whether
Well,
whether they can be evicted from the ITI land or not, I using this notice, Lordship. The question, one of the question is here.
ITI নামত থকা মাটি।
Lordship. Lordship may come to 18 rule, section 18, Lordship, rule 18.
সেইখন চাওঁ, লেণ্ড ৰেগুলেশ্যনখন। এই ডাঙৰ কোনটো? ডেট হ'ব লাগে, লাগিয়ে থাকে। Bench 5. Yes, please. Yes.
Yes, sir. Rule 18 states ejectment, Lordship. Subject as hereinafter provided, the deputy commissioner may eject any person from land over which no person has acquired the rights of proprietor, landholder, or settlement holder. Now, clause 2, Lordship, sub clause 2. When such person has entered into possession of government khas land or wasteland or estate over which no person has acquired the rights of proprietor, landholder or settlement holder, or any land that has previously been reserved for roads or roadside lands or for grazing of village cattle or for other public purposes, or has entered into possession of land from which he has been excluded by general or special orders, and when further there is no bona fide claim of rights involved, he may be ejected or ordered to vacate the land forthwith, and the deputy commissioner may sell, confiscate, or destroy any crop raised or any building or other constructions erected without authority on the land. So here, Lordship, they are saying that the land, government khas land or wasteland or estate over which no person has acquired the rights of proprietor, landholder, or settlement holder, or any, and provided there should be no bona fide claim of right involved should be. No, that right should not be there. Here, Lordship, some bona fide claim has arrived, Lordship. Lordship may come to
But what about subsection 3,
subsection 3.
18.3?
Subsection 3.
Because read 18 as a whole, ejectment.
Lordship.
Subject is hereinafter provided, the deputy commissioner may eject any person
Lordship.
from land
Hmm.
over which no person has acquired the rights of a proprietor, landholder, or settlement holder. Now, there are two subsections,
Lordship.
2
Two
and
say
3.
2 and
For 2, there is no contemplation of notice.
yes.
And 3 says in all other cases, such ejectment will be preceded by publication of a notice.
Notice has been.
So the general power under subsection 1 is to eject any person who has not acquired the rights of a proprietor, landholder, or a settlement holder.
Lordship.
So that is the substantive portion. Now, how do you proceed? There are two classes.
Lordship.
One is government khas land, grazing land,
Yeah.
all those where there is no contemplation of a notice.
Lordship.
And second, in any other case,
Notice
it
is
has to be preceded by a notice.
notice. So in the second clause, it said that there is no bona fide claim also.
Yes.
That is also there provided that if some bona fide claim arises, then Lordship may look into that one. So may I read 3, Lordship?
Yes.
Lordship 3A. In all other cases, ejectment shall be preceded by publication of a notice in the manner prescribed below, requiring the occupant generally to vacate the land specified in the notice within 15 days of the date of publication of the notice on the land concerned or in a prominent place in the vicinity thereof. And
Okay, what is your submission?
my submission is that Lordship, that notice, my first submission is that the notice is not maintainable. Lordship, it's IT island. And Lordship, may now come to they have been paying Lordship. These are not revenue, Lordship, but they have been at page 13,
1-3.
1-3,
Yes, please.
1-3. 1-3 is the original one, Lordship. Lordship.
Yes.
Therefore, for 2009 and 10, Bedokholi Jorimona. They have been paying that also, Lordship. Earlier, since 1983, from 1980-83, they have been paying.
Yes.
At page 10, the receipt, the revenue receipt of 1980 is there. Page 10, Lordship. Then thereafter, Lordship, annexes page 15, Lordship, may page
1-5.
1-5. I am Lordship referring to the original only.
Yes, yes.
In the vernacular, Lordship. Regarding, I am showing this regarding the bona fide claim arise within the for the petitioner's law.
Yes.
Page 15. This is the Lordship original of Sakra o Moza Dhukokhana, Mohaguli Circle, and Lordship at the first column 195. Dark number is 195. Lordship, the last column. Go Soronia Pothar, Dokholor Prostab, Dulal Gogoi. So, Prostab, Lordship, that proposal has been, Lordship. Proposal has been sent for their Lordship.
Where do you get?
At page 15, last column, Lordship, 11. Column number 11. In Assamese.
Yes, yes. What is it?
Go Soronia Pothar, Dokholkar o Prostab. The Sri Dulal Gogoi. So, proposal has been sent. Next page also, Lordship. Next page, it is clear is there regarding the petitioner number 2.
This is Go Soronia means what? Grazing land.
Grazing land. Then subsequently they are saying it has been de-reserved. So I am coming to that also. Lordship.
Can you de-reserve grazing land?
So it is their documents.
Now, can you de-reserve?
Lordship, there it is suitable for settlement. It is written there. It is suitable for settlement. They are contradicting by own documents, Lordship. Lordship may come to page 20 for that. No, page 21, the original one. Whereby they are saying that
Page
21, where they are saying that it's suitable for the settlement and de-reserved.
21.
Page 21.
Yes.
At the top, Lordship, it's not that much clear. At the top, it's written সংরক্ষণ মুক্ত.
Where is it?
At the top. First.
It is not visible. It's not.
Or that original copy is not with me, Lordship, but it's সংরক্ষণ মুক্ত. Type copy is also there, but some typographical error. Page 20 is the type copy.
20, where in 20?
1.
Yes, 20, which one? Okay. Which column?
No, 21, Lordship.
No, in the
type copy.
translated copy.
Translated copy, Lordship. At the top, it is written LATER, letter of unreservation. It should have been, Lordship, letter of de-reservation. সংরক্ষণ মুক্ত in Assamese it should have been the typographical error is there.
Where do you get সংরক্ষণ মুক্ত?
Lordship.
It is not
At the
there.
top, Lordship. At the top.
Gaon so and so.
Yeah, Gao Mohaguli Sapori.
Moza.
Above that, সংরক্ষণ মুক্ত.
There is nothing here.
Okay, then also, Lordship, we can come from we can see from the columns. It's there. In column number 2, in the same page, page
Yes.
21.
Yes.
May I read that?
Yes.
Dhukokhana Mouzar Mohaguli Sapori so and so 195 Dagor Go and পাঁচ কথা 1 বিঘা মাটি some that volume is there. Then কিহৰ বাবে উপযোগী? Third column, it is important. Third column. Lordship, got it? কিহৰ বাবে উপযোগী?
Yes.
It is there ঘৰ বনোৱাৰ বাবে উপযোগী. Then সংৰক্ষণ কৰিব লগা মাটি It is there 195 দাগৰ grazing মাটি, column 4.
Yes.
Then column 5 লক্ষিত ওচৰৰ ওচৰৰ জমি সংৰক্ষণৰ মাটিৰ পৰা কিমান দূৰত? Then the written lordship চৰণীয়া পথাৰৰ সংৰক্ষণৰ ভিতৰত নপৰে.
Yes.
Yes, lordship. Next column.
This was of 97.
This is of 1997. Okay. They have been occupying there since lordship 1980 for the last 45 years.
Now, after 97, what has happened? After this?
After this lordship, they have this issued the notice only. Nothing else. And lordship, since their proposal has been sent for settlement also, so lordship, some bona fide claim right has been lordship accrued on them, lordship. So being the landless people, flood affected people of Lakhimpur district and lordship, they have been residing there for the last 45 years. So lordship, whether this eviction is maintainable or not, that is also questionable.
Yes.
But the petitioner's proposal was placed before subdivisional land advisory committee lordship, and that was cancelled because it is lordship Kostabita Mati Gupasharar Mati.
Prastabita?
Mati Gupasharar Mati, it is Vijay land.
Oh, Vijayland.
Lot, yes, that is why it proposal was cancelled.
Lordship, may I point out one thing in between?
We'll come back to you, let him.
Yes.
Yes.
And we have filed affidavit lordship. It will categorically mention that land is Vijay land. That's paragraph 5 of our affidavit lordship.
Affidavit is filed by Food Supply and Consumer Affairs lordship.
No, he's authorized lordship.
Yes.
That is his authorized lordship.
Paragraph?
5.
Not 5, 4, I think. 4.
4 is also there.
5 is.
Oh, sorry, 4, 5, it's some.
Actually, they have filed 2 affidavits lordship. 2 affidavits are there.
No, no, it will
নহয় দুখন আছে সেইকাৰণে কোৰ্টে দুখন আছে Two affidavits shown by 2 different officials. Both are sub inspector food and civil supplies consumer affairs.
No, same officer. He has filed 2 affidavit, one on behalf of respondent number 2,
Lordship.
one on behalf of respondent number 4.
Lordship. In the affidavit filed with respondent number 2 lordship.
Two.
Oh, that's it. That's paragraph 4, sub-paragraph lordship.
Or 4. Okay. In our respondent number 2's affidavit,
Lordship.
paragraph 4.
Lordship.
We have not understood, Mr. Goswami. 4 and 5, paragraph 4 and subpara. Please read.
Second,
Both at that as regards, please read.
that as regards to the statement made in paragraph 6 of the resolution, the deponent begs to state that a proposal against the land measuring 2 bighas 10 dasas bearing tag number so and so under Dhukuakhana Moja in favor of Srimati Hukeshwari Kaur.
Who is this Hukeshwari Kaur?
Petition number 2. Petition number 2.
She is the mother of the petition number 2, not the petition number 2. Mother of the petition number 2.
Lordship.
Gopal, yes, Lordship.
Precedent was passed on 23/9/1997, correct?
Lordship.
So far as petition number 2, has it been settled? Are you in touch with your clients?
No, no.
I think so far as petition number 2, it has been settled.
No communication with them. That's it.
Second para, if you see second para has said that,
Yes,
please,
yes.
second para is also not very clear.
Yes, not clear.
But the reservation was not done, Lordship.
Huh?
The reservation was not done, Lordship.
But a proposal for de-reservation entire land was
Yes.
accepted
Accepted, it is
in
there.
the same meeting and directed the then circle officer to prepare de-reservation proposal.
Yes.
From where are you saying the de-reservation is not done?
I have the instruction, Lordship. That was
Let's
not.
see. This instruction is only for one of the petitioners, Dulal Gogoi.
Lordship.
I think for petition number 2, your grievances have been redressed.
No, might be. wrong.
Because the latest
Yes.
instructions, which is of 2023,
23.
Not so.
it only says that Dulal Gogoi's proposal could not be taken ahead because the present status of the land in question is VGR and it is not de-reserved.
Lordship, then that shows might have been Lordship settled. Second one.
Second one.
Might have.
Second one is not dealt with. Second one, there is an affidavit.
But a proposal for de-reservation entire land. They are saying entire land, in entire 195
No,
the
that was not done. After office record is seen, the allotment proposal of Dulalgo was placed in the SD subdivision and land advisory committee meeting held on 28/1/1999. And the committee had kept the proposal pending for future verification as it was VGR land. Okay. You want to say anything more?
yes, Lordship. regarding the.
We'll record that so far as petition number 3 is concerned, it appears that the grievances appears to have been redressed. But one, if it is easier, we cannot. Difficult.
Petition number one.
Lift.
Then he may be lordship allowed to pray for lordship settlement by filing.
Under the new present policy, you can pray for.
So, your lordship, according to Jampal Singh, your lordship, grazing land cannot be allotted.
Is it?
Yes, sir. 1011.
We are not
Lordship
aware of
knows
this.
everything.
Please have your seat, Mr. Ravinder.
Lordship, may I place one judgment regarding the bona fide claim of our court?
Not the question. Mr. Ravinder, you are not on record.
No, lordship, I am not.
First, 3 A.R. Ravinder, Learned Counsel for the petitioners. Also heard Sri N. Goswami,
For 2, 3 and 4.
Learned State Council, as well as Miss
1.
P. Baudelaire, N. Baudelaire, Learned Standing Council, Revenue Department, Para. As per the petitioners, who are 2 in numbers, are aggrieved by a notice dated 22/9/2014, issued by the Circle Officer, Hukwakhana Revenue Circle, directing them to vacate the land by stating that they are in unauthorized occupation of land in the name of the Industrial Training Institute. Full stop, para. As per the facts projected, the petitioners are flood affected persons and are in occupation of the plots of land since the year 1980. Full stop. The said plot is covered by Doug number 195 of Mohokuli map of Hukwakhana Revenue Circle, and they have constructed permanent structure. Full stop. It is also claimed that they are in peaceful possession and are paying the revenue, and their names are also reflected in the chita of the concerned village. Full stop. Sri Tavildar, the Learned Council, has also submitted that the land under the occupation of the petitioners were de-reserved by a communication dated 15/2/1997, in spite of which the impugned order dated 22/9/2014 has been passed. Full stop. Para. By drawing the attention of this court to Rule 18 of the rules under the Land Revenue Regulation, the Learned Council has submitted that the notice, impugned notice, that the aforesaid provision, and that though the aforesaid provision is mentioned in the impugned notice, the same has no application. Full stop. He has elaborated his submission that certain conditions have been mentioned for such a notice to be made under section 18(2), and those conditions are not present in the instant case, as the notice itself states that it is land of the ITI. Full stop. the learned counsel has also drawn the attention of this court to the revenue receipts. Full stop. He has also referred to the proposal for settlement of the land in question and has submitted that the petitioners are bona fide occupiers. Full stop. There. 3. N. Goswami, learned counsel for the petitioner, for learned state counsel, has submitted that 2 affidavits in opposition, as affidavits of assent, have been filed by the respondent numbers 2 and 4 on 30/4/2019. Full stop. It is submitted that so far as the petitioner number 1 is concerned, though there was a proposal for de-reserving, the same could not be done as the land in question is grazing land. Full stop. However, the affidavit is silent on the aspect of the affidavit, the said affidavit has also mentioned the name of, I mentioned the case pertaining to the mother of the petition number 2, that's Srimati Bhukeshwari Kaur, regarding a proposal which was taken by the SDLAC in its meeting held on 23/9/1997. Para? 3. Tavildar, Ms. Baudelaire, the learned standing council revenue, has supported the views expressed by the learned state council and has also submitted that that so far as grazing lands are concerned, the same are required to be kept encroachment free. And in this connection, she has relied upon the case of the Honorable Supreme Court in Jagpal Singh versus State of Punjab, reported in 2011. So, Sri Tavildar, the learned counsel, has clarified that has informed that the clients are not in touch and therefore he is not in a position to assert regarding the settlement which the respondent with the petition number 2. The contention, the primary contention of the petitioners, of the learned counsel for the petitioners is that section rule 18(2) is not applicable as the same as the conditions mentioned in the section are not fulfilled. Full stop. The specific contention is that the land in question is land belonging to the ITI and not government land. Full stop. The aforesaid contention is, however, unable to be accepted by this court as ITI is a government institute and it automatically flows that the property, including the land, is government land. Full stop. So far as the aspect of payment of revenue is concerned, a close perusal of the receipt would show that the payments are in the form of bedokoli jorimona, which in other words is a fine for unauthorized occupation. Full stop. In this connection, one may gainfully refer to the case of Radha Kanu versus State of Assam, in which the Honorable Supreme Court has clarified the position that Toji, Bahi, or bedokoli jorimona is only a fine and would not vest any right to the payer full stop. It also transpires that the land in question is Go Saranya, italics, huh? Bracket grazing land, full stop. From the affidavit, from the two affidavits filed on 30/4/2019, it however appears that there was a proposal for dereserving the land, and in fact, so far as the mother of the petition number 2 is concerned, there was a proposal by the SDLAC in its meeting held on 23/9/1997 for allotment, for settlement of a plot of land, full stop. It appears that so far as petition number 2 is concerned, there may not be any existing grievance, full stop. So far as the petition number 1 is concerned, though a statement, it has been stated in the affidavit that though there was a proposal for dereserving the land, no, it has been stated that the proposal for settlement was rejected as the land was reserved for grazing, full stop. It has also been stated that a proposal for dereserving the land in question was accepted for certain other plots of land. Para Sri Goswami, the London State Council, has placed before this court written instructions dated 28/11/2023. Full stop. As per the same, so far as the petition number 1 is concerned, the settlement could not be done as the status of the land in question is vizier land and has not been dereserved till date. In the aforesaid case of Jagpal Supra, it has been clearly laid down that grazing lands are community lands and are not to be dereserved for any private person. Full stop. In view of the above, this court is of the opinion that so far as the petition number 2 is concerned, there is no requirement of any further adjudication as the grievance appears to have been redressed. Full stop. So far as the petition number 1 is concerned, the relief paid for cannot be granted by this court in view of the aforesaid discussion. Full stop. The petitioner number 1 is, however, at liberty to apply for settlement of land under the existing policy, including the Vasundhara. Vasundhara, what do you say? Vasundhara. Including the Vasundhara scheme, by stating, by highlighting the aspect of long possession of the land in question. No, sir. Vasundhara scheme. That part it cannot be because it's grazing. Okay. We have this on record. Written instructions, copy of the written instructions dated 28/11/2023 is made part of the records. It will photocopy the word. Obligations.
May it please the Lordship. My lord, the review petitioner before Lordships, not it is an central government PSU, my lord. Now, I just got some here checkered history, but be that as it may. Now we preferred review petition before the division bench, but division bench was of the view that we should approach your lordships, and that is how the matter is before lordship. Now, Lord, presently I am operating the contract. I means the review petitioner. Now, my term will come to an end on 31st. Yes. Now, what had happened, my lord, on 1/10/22, an NIT was issued.
110?
9/22.
Yes.
Now, pursuant to that, my lord, on 28/6/23, National Health Mission issued an, we may call it work order, they call it, my lord, SLA, in favor of
What is SLA?
respondent number 4.
What is SLA?
Service level agreement. Actually, it's a, my lord, mobile medical unit service provider.
NIT for mobile medical unit.
Yes, mobile medical service.
And this service level agreement was with
With respondent number 4, R4. Now, my lord, we assail the SLA.
The grant of the work to respond number 4 was the subject matter
SL
challenge.
is subject matter of WPC number 2049 of 23.
WPC
2049 of 23.
Yes. This
By
28/6 was challenged.
yes, 28/6/23 was challenged by order dated 4/5/23. The writ petition was dismissed. The judgment is at, my lord, page 55. Then, my lord, we preferred a writ appeal.
Okay.
Writ appeal 165 of 23, which was also dismissed on 24/5/23.
Yes.
Against the division bench order, my lord, we preferred an SLP.
Okay.
SLP number 14928 of 23,
149
28 of 23.
14928.
Yes. My lord, by order dated 21/7/23, notice was issued.
Yes.
Then on, my lord, 13/10/23, an order of status quo was passed by the Honorable Supreme Court,
Yes.
which your lordships will notice at 155 page. Thereafter, my lord, when the matter was listed before the Apex Court on 17/1/25, since the records were
The
made
status quo continued from 23 to
yes, even till today it is continuing. Now, on 17/1/25, when the records were produced, was available before the Honorable Supreme Court, an opportunity was given to us, in fact, to both the parties, my lord, to inspect the records. Thereafter, my lord, on 18/3/25, the SLP was dismissed
yes.
in limine, my lord.
Not in limine at SLP. Notice was issued on 21/7.
It was not a speaking order, my lord, dismissed.
Okay.
Yes. It is at page 75, my lord.
Yes.
Going by the language, my lord, though notice was issued, it looks like we are not inclined to interfere with the impugned judgment. Hence, present special leave petition is dismissed.
Yes.
Then, my lord, we preferred a review because it was in limine, my lord. We preferred a review petition before the learned Honorable Division Bench, my lord. Now, Honorable Division Bench was of the view that we should prefer the, my lord, review petition before your lordship. That is how we are before your lordships. The division bench,
Review before the DB was numbered as what?
I'm giving it in, my lord. RA 43 of 25.
Before DB.
DB.
After dismissal of the SLP.
Yes.
Okay, DB passed an order.
Yes, DB passed an order which your lordships will get at 157.
Order dated?
Order dated, my lord, 9th of May 2025.
Approach the single bench.
Yes,
Okay.
hence review petition is now, that is how before your lordships. Now, my lord, the sum and substance is from inspection and other sources, my lord, we got to know the credential certificates which were submitted by the respondent number 4. I won't use the word force, my lord, but these are documents based on which it is not possible to adjudge the eligibility of a bidder, my lord. For example, if your lordship will kindly come to page 81. Page 81, my lord.
'81.
Yes. Evaluation of technical proposal. If your lordship should kindly come to 1, bidder must, sorry, my lord, page 81.
81.
Procedure of
Yes,
evaluation.
procedure of evaluation of bids.
Evaluation of technical proposal. Bidder must fulfill the eligibility criteria mentioned in section 5.
Yes.
Now, if your lordship should kindly come to page 84, my lord. Eligibility criteria. Section 5, clause para 2, clause 2. The bidder.
Eligibility criteria at page, section 5, okay.
Yes, section 5.
Yes,
I'll have your lordship's kind attention to 2, my lord.
yes.
The bidder, and in case of consortium, all the participants shall have at least 3 years experience in providing medical care at community level. In support of this, a statement regarding assignments of similar nature successfully completed during the last 3 years should be submitted as per pro forma in Appendix A. Now, the Appendix A is at page 89, my lord. Basically, the requirement is that in the last 3 years that you have provided similar services that you must demonstrate. Kindly see page 89, Appendix A. Community-based health services provided in last 3 years.
87.
89, no?
89. Yes. Please. This is the
Is
appendix.
the appendix. Now, on top, my lord, community-based health services provided in last 3 years.
Yes.
Attach user certificate in original. Kindly mark this, my lord, in original. Regarding satisfactory completion of assignments, etc., etc.
Yes.
Now, my lord will kindly come to their supporting documents. In support of this, on the, my lord, what I beg to submit is, these were the materials which were given in Annexure A.
Page?
159. Lord, I'm sorry, Lord, that there may be some, may not be very clear copy. These are the original copies. Movie also saying to me. Moi movie was like maybe. I say movie was saying.
Page number
Yes.
Please come to page 159, Miller.
Yes.
To whom it may concern, on top, Lordship will kindly mark the date 38/2021.
Yes.
Yes. Certificate of satisfactory performance. This is given by my lord, Odisha, no? Government of Odisha. Office of the Chief District Medical and Public Health Officer, Sundargarh. This is to certify that community action through motivation program CAMP was issued. CAMP is the respondent number 4, my lord. A LOA dated 4/1/2020, whereafter an agreement.
What is the CAM?
CAMP is the respondent number 4, my lord.
What is the full form?
Yes. I'm just giving, my lord. Community action through motivation program CAMP.
Oh, okay, that is the
Yes.
CAMP.
Yes. Community action through motivation program.
Okay.
Kindly see, my lord, supposedly the LOA is dated 4/1/2020, and thereafter, my lord, an agreement was signed on 28th of March 27. So this is a document based on which the state of Assam National Mission, my lord, recorded its satisfaction. I do not know how it is possible. And kindly see down below, my lord. And now the certificate is being issued by one chief district medical and public officer. He signs as 36/21. So, my lord, the work order is of 4/1/2020. Agreement is signed on 28th of March 2017, and it is signed on 2 dates. One is 36/21 and other is 38/21. Now, my lord, will kindly come to page numbers 160. This is another document issued by the same authority.
160.
Yes. This is for another work, maybe. Another work.
This is for GPS operation mobile units. This is for emergency patient transportation service.
My lord will kindly revert back to page number 159 for a moment, my lord.
Yes.
Please come to that clause 6. Brief description of the scope of the work, explaining the precise nature of contract and services being rendered by bidder, operation of GPS. This is operation of GPS based fitted 25 number of mobile medical unit vehicle. And at page 160, my lord, same paragraph 6, it is 54 number of GPS fitted ambulance linked to centralized cell center accessible on 24/7 basis. Now here what your lordships will notice is at page 160, whether from the legible copy which we have given or from the other one, my lord. Now this is a document which was issued on purportedly on 36/2021.
Yes.
So therefore, on the left hand side, kindly see, my lord, 3698
Yes.
letter number 3698.
Yes.
It should have been, my lord, 3696 because it is issued in the month of June.
Compared to 159.
No,
If
it's
your
the
lordship
left-
kindly comes to 159, in 159, kindly see letter number is 3697.
2 months, 2 months after.
After
2 months.
2 months afterwards.
After.
Now your lordships will kindly come to page number 161. This same authority, my lord, issued an experience certificate to the review petitioner. This is in this form. Approval letter.
Page?
161.
Sample.
This is a sample letter we have given, my lord, in respect of some other work.
161.
from the same authority. Kindly similar, their letterhead is different, their hologram is different.
Signing right side.
Signing on the right hand side, here it is on the left hand side.
My operator.
And here the chief district medical officer himself is signing, whereas in the so-called my lord experience certificate, it is by some authorized signatory. So these are the documents based on which, my lord, the satisfaction was derived at. Now, my lord will kindly, these are the 3 documents pertaining to experience certificate given by Orissa authority in favor of respondent number 4. Now, my lord will kindly come to page 162.
But these certificates are of different period.
Yes,
The
yes.
earlier one of the 21,
Yes.
there may be change of designation.
No, my lord. No,
The-
I am not talking about the designation part. What I am saying is,
Yes.
in our certificate, it is issued by the Miller authority itself.
Okay.
Whereas in case of the experience certificate, it is by some authorized signatory. Apart from the Miller inconsistencies and incongruities in the dates. Now, there are further materials, my lord, to show that he was not eligible. Basically, we are trying to project a case of fraud, my lord. So it will vitiate everything, including any solemn acts. Now, if your lordship kindly comes to 162, my lord. If your lordship would kindly have the clear copy, legible copy which we have given.
Yes.
Same copy. On top, lordship will see it is 26/11/2019. Now please come towards the bottom, my lord. The adhikari who signs it, 26/11/13.
26/11.
And he is certifying a work for the period
No,
performed
Where do you get the top date? 26/11?
2019 on top, my lord.
Is it 19? Is it?
Yes, 26/11/19. But now they have issued some fresh certificates there in their affidavit. There it is 2019. Yes.
19, I think.
Yes, 19, my lord. No, why it has to be 19 because you kindly see, my lord, the work was performed between 2012 to 19. Therefore, it could not have been issued in 2013.
Yes.
A work which is going to be completed or done in, my lord, the following year,
Yes.
how can a certificate precede that, my lord? At best, it can say that work may be awarded.
Yes.
But that certifying that the work has been done, it could not have been in 13. And these are the part of the NIT, my lord, based on which he is held to be technically eligible.
R4.
Then R4. Now, my lord will kindly come to page 163. That is the English translation, my lord.
Yes.
Now, very importantly, please come to page 164. Now, this is the minutes of the National Health Mission Assam. Now, this is a minutes of the proceedings of, my lord, 26/12/22. May I read it from the first subpara? Meeting of the Technical Evaluation Committee was held on 26/12/22 for evaluation of technical bids received against the tender for finalization of rate contract of 1 camp to be conducted by Mobile Medical Unit Team. Now, kindly see, my lord, serial number 5.
Yes.
Yes. Now, I'll have your lordship's attention to the last Roman 2, my lord. Some experience certificates submitted by the bidder are also not legible. And some anomalies are also seen in such, seen as such. The committee has recommended for seeking clarification in this regard and for submission of experience certificate of MMU service for the last 3 years. So, my lord, therefore, from the records, government will have to satisfy that pursuant to this, the matter was followed up and satisfactory. Yes. Now, please come to the next page, my lord, page 165. Remark. After detailed discussion, the committee rejected their technical bid as they have not submitted. Sorry, I'm sorry, my lord.
This is
A
clear.
remark on top, my lord.
Yes.
The bidder shall have to submit the said document within 3 days from the date of publicity of the document for such clarification. That means from my lord
2612.
26/12, that is by 29/12, they have to have give. Next to this.
Was it done?
Yes, Miller.
Was it done within 3 days?
No. Which is the timeline they ask 3 months of which is that clause? 4.5.
According to you, this clarification was not made by the respondent number 4.
Now, Milord will kindly come to page number 344, Milord. I'll draw your lordship's kind attention to the contractual clause.
344.
Yes. This is the service level agreement, Milord, 4.5.
The
It
subject matter,
starts at 341.
the subject matter of your challenge.
Yes. But I'll have your lordship's kind attention to clause 4.5 at page 344. The service provider agency would be required to commence the mobile medical unit operations, including regular health camp in 34 district through 130 MMU.
You are reading which one?
Page 344, 4.5.
4.5.
Yes.
Yes, please.
The service provider agency would be required to commence the mobile medical unit operations, including regular health camps in 34 districts through 130 MMU at 130 diagnostics plus 130 TTTV complete, so and so, etc., etc. Within preparatory time, but not more than 90 days from the date of signing this service level agreement, failing which this service level agreement will stand null and void and shall lead to forfeiting of performance security as per conditions of tender. Now, my lord will kindly take note, 28/6/23 is the date of SLA.
28?
6/23.
Okay.
And 90 days comes to an end on 26/9/23. Now, even if we
28/9/23.
yes, my lord. 26/9 September 23 is the end date. Then Supreme Court status quo order was on 13/10/23. That was after this, my lord.
Yes.
Now, my lord will kindly come to page number 322. Further extensions were given, my lord. This is on 4/10/23. Minutes of the meeting of review the preparedness of the MME unit to be organized by so and so. That is R4. If your lordships would kindly come to the heading record of proceedings of the meeting number 2. MMU vehicles should be ready in all respects and should reach their place of stationing within 2 days, that is by 5th of October. So earlier it was, my lord, 26/9/23. So now it is extended up to 5th of October 23 without fail. Then at page 324, there is another extension, my lord.
No, Mr. Chaudhary, your review is structured on what grounds? Discovery of new
Fraud.
facts.
Discovery of, no, my lord, number one, it is a case of fraud. And secondly, discovery of new fact. In spite of exercise of due diligence, my lord.
No, that we have.
But it's a clear case of fraud, my lord. I'll establish, my lord. Now, my lord, now they filed an affidavit in opposition where they are made their case worse, my lord. Now they are supporting us in effect. Because now there is a third case developed. That the third case which is sought to be developed was not before, those documents are not before the, my lord, settling authority. Then on what basis you derive the satisfaction regarding the, my lord, experience? So our case would be, since they have not been able to take over till date, there should be a fresh tender, my lord. Enough is enough. Because you have not, my lord,
What was the tenure?
3 years, 3 years, no?
Now, how is it running now, Mr.
We are running, my lord.
Petitioner.
On the basis of what?
Status quo order.
Not
You-
status
you-
quo, my lord, we see, my lord,
No,
initially,
one-
there was a
one
petition.
second. You were in the earlier, you were.
Last year I was doing.
Yes.
Okay, we'll continue at 2.
At 2 o'clock. Develop.
Basic overlay.
আরে একটু টাইম লাগবে এইটো কৰি আৰু ফুটি নকৰে
এতিয়া কমলা এখন দেখুৱাব লাগে স্যাম্পল
আমি 5 মিনিট আগতে আহিম
আমি ইয়াতে আছো কিন্তু
কালি এসবি
questions. My lord will kindly have, I'll trouble your lordships with page 160 again.
160.
Yes, 160, my lord.
Yes.
Now, lordship will notice the inconsistencies in the dates. That I have already shown, my lord. Now they have filed an affidavit where right to improve upon their case. For that, lordships will kindly come to page 395. I'll just place 3 documents and I'll place 2 judgments. That's all, my lord.
395.
5 million. It's a part of the affidavit filed by respondent number 2 and 3.
covering letter 390.
The covering letter, lordships will
Just a-
notice
just a-
at page
just-
394.
Just a minute, please. This is affidavit opposition by whom?
By 2 and 3 million.
NHM.
National, yes, Health Mission. এটা একটা বেলেগ বস্তু নেকি NH7 তো বেলেগ ও মানে হেলথ মিশন মানে সব আৰু
395.
yes madam.
Yes.
Kindly see, my lord, it's a part of that letter which has been forwarded by the Orissa authority purportedly. Now, serial number 1, they refer to that, my lord, letter 1546. Then there is a column called confirmation sought on the content of reference document. So this is the document 41-2020, which your lordship finds at page 160. Now kindly see, my lord, the verification remark. As per record, actual correct date of the letter is 4/1/20. While letter number so and so for operation and management of 37 number of ambulance service and 13 number of Mahaprayan vehicle. Now say that this letter is 4/1/2020. Now, your lordship will kindly take the trouble of coming back to me, Lord, page number 160 once again. Lordship can refer to that loose letter also, which I have given.
Yes, yes.
Please come to paragraph 6. Brief description of the scope of the work, explaining precise nature of the contract and the service being rendered by so-and-so scope of the work is to provide emergency patient transportation service through 54 number of GPS, GIS fitted ambulance. Now at page 395, they are saying, my lord, 35 plus 13, it is, my lord, 50, no, 48.
It will be 50.
37.
37 plus 13, 50.
Yes, 50. Whereas, my lord, the original is of 50. So much of discrepancy cannot happen, my lord. I can appreciate in a particular place there is a date which may have been inadvertently typed out or something. But consistently, these discrepancies cannot arise. So, my lord, therefore, this document is not at all, my lord, liable to be accepted. In any case, my lord, which document was before the settling authority when they recorded the satisfaction that respondent number 4 qualifies the his bid is responsive. So definitely these documents are not there. And when this came, my lord, on 8/5/25, and they have finalized the contract in 23. So they finalized the contract based
Where
on
you get this date? 8/5.
left hand side, my lord, first,
Yes.
second column.
Yes.
Yes. Then, my lord, I'll trouble your lordships with the second one. This is very interesting. Now, this is number is dated 36/21. Then please come to the verification part. Number 3697 so-and-so dated 36/21 is the original experience certificate. Issued number of so-and-so of the ambulance service has been entry wrongly in the experience certificate. They say, as per the record of the correct LOA of MOU service is later dated 24/12/16, followed by agreement dated 28th of March 2016. Now, just to appreciate it, if your lordship would kindly have 159, my lord.
Yes.
Kindly see.
MOU 17.
Kindly see, my lord, it is 38/21. They say 36/21 has been wrongly typed out, but it should have been 16. Now,
But-
if it is
36 is the date which is with the signature at the bottom.
yes, but on top it is 38/21. Now, that is not the issue. My lord, the most important issue is, lordship knows the experience should be of the last 3 years. Now, if the work is of 2016, then how does he have the experience? Because as per page 81, the experience should be of the preceding 3 years. The preceding 3 years should start from 2021, 21-22, 22-23. Sorry, 19-20, 20-21, 21-22. Whereas this is of, the agreement is of 17 million. Either of the documents, my lord, could not have formed the basis for deriving the satisfaction that respondent number 4's technical bid is responsive.
As per record, whose record, not NHM record.
And naturally, my lord, record of the that Odisha authority, not of the NHM, my lord.
How did NHM plan?
As per the expenses.
On the basis of 2017 and
Now,
20.
is it possible, can we visualize a scene, my lord, in a tender finalization process, on basis of some wrong document, you initially derive the satisfaction. Subsequently, you try to correct yourself by getting an explanation. Whereas the minutes of 26/12/21 itself said, get the confirmation from the party. Why they did not do that? So this is a very serious infirmity, my lord. This goes to the root of the matter.
But this 54 number of vehicles
Yes, my lord.
is in connection with page 160.
Yes.
See the last one, number 3698, this is the number of the letter.
Lordship is reading 160, my lord.
No, 395.
Yes.
Where do it 160?
On regarding first one, my lord.
Regarding the third one.
Or third one.
Because
Third one is down below, yes.
yes, because it's the letter number is 3698.
Yes.
This is the letter at page 160.
Yes.
Date 36 to 2021.
Hmm.
All now, as per the experience certificate, reference is so and so, and number so. Please confirm the LON, memorandum and number and date. Then second, LO was issued for service of so and so vehicles and so. However, the experience is given as 54. See the remarks, verification. As per the record, LOA is so and the agreement is dated 4th February 2020. In between the second one, in between the period March 2020 to the date certificate was issued, two additional Mahaprayan vehicle was added and added ultimately the number of vehicles is 54.
54. They try to improve. Then what? Why, my lord, this first para? Why this first para? My lord, they are dealing with two separate aspects. Serial number 1 and 3, though it pertains to page 160, but they're dealing with two different aspects.
No, first para is pertaining to document number 1546. What is 1546?
386.
386, my lord.
Let us see
Where
386.
again there's a typographical error. According to them.
386. Every time it cannot be typographical error. Typographical error of error.
Here this
Yes.
is 1-4.
Now kindly see my lord 386. Now it is 4-1 has become 1-4. Page 386.
This is our letter asking for clarification of 160 only. 160 has 35 DM, 4120. Yarako 14 kore disu. It's all relatable to page 160.
Page 386, my lord.
Yes.
Kindly see 35 DMF. Now it is 1-4-2020.
At page 160, it was 4-1.
At 160 it is 4-1, 395 also 4-1.
Yes.
Now it is 1-4. So clarification must be correct. You can't give clarification of otherwise there will be no end to it.
Just a minute, please.
At the behest of review petitioner, it is also not while granting.
The serial number 1 is not in connection with 160, it is in connection with 386.
No, both, my lord.
386 is 160.
386 relatable to 160 and 395 serial number 1 is also relatable to 160.
160 declared by into the this is 35 DM 35.
If your lordship would kindly come to page 160, my lord, for a moment.
There are
Letter number 35 DMF, dated 4-1-2020. At page 160, second sentence, LOA while letter number 35/DMF, dated 4-1-2020.
Then re-clarifying and 4-1. Pratham clarify. এইটো যে ৰিলাই কৰিছে এইটো 2017 আৰু 20 ক্লাৰিফিকেশন কৰিছে কিন্তু একো ৰেকৰ্ডত নাই এনএচএম also doesn't know about it.
My lord, I was referring to 395, the second one, my lord,
Yes.
whereby a clarification was sought to be given that the date 36/21 is not correct. Actually, the letter should have been 24/12/16. And secondly, my lord, the memorandum was executed on 20th of March 2017. Now, my lord, are these documents in the record of authority?
Because what is on record says contrary.
My lord, we have not seen those documents. Neither had it been annexed to the petition or to the affidavit. So these are in the record of maybe that's Odisha authority. Now the question is, on what basis you came to the conclusion that the tender of R4 is, my lord, responsive?
On this basis. It has
Because
been
on the last date of submission, these documents are not there. Neither they have been able to produce the vehicle within 90 days plus the extended period. So today, by going by the tender conditions, National Health Mission should cancel the order and forfeit the performance guarantee.
What was the tenure of the contract?
No, my lord, if they do not place
No,
the
tenure otherwise.
3 years plus additional 2 years. If service is satisfactory, in that case, my lord, there is a provision for 2 years extension.
Okay.
So my humble submission is, my lord,
3 years expiring.
this is a clear case where everybody, my lord, abused their authority. You reject my tender on the supposed ground that I do not conform to a particular requirement. Now, you as a tender inviting authority, you are equally bound by the same clause. If somebody's tender is not compliant, how can you accept it? Para 11 of, my lord, International Airport Authority. Daram Sethi. So, my lord, qua page 160 and page 159, the clarification which is now forthcoming in our humble submission, subject to your lordships may say, are absolutely not acceptable, my lord. More so, these explanations were not there on the last date of submission of the bid. Therefore, these are materials which are extraneous. That's why, my lord, in West Bengal State Electricity Board's case, Supreme Court says, the best way to ensure transparency is to follow the tender conditions. The moment you do not follow the tender condition, there is an element of arbitrariness which creeps in.
Original to Persia. Format.
C5.
Reply to this.
Okay, বাকি কিটা ডকুমেন্টে দেখাই নাও মুজি PDF আর with once
Format.
the exact facts को खत्म कर लेते हैं बाकी किता फिर मेरा है ना before that the pleadings. Now, if your lordship should kindly come to page 456, my lord. Why this leeway is given, my lord, in a so-called transparent procedure? Please come to 456. 456 for affidavit to court, no?
You are referring to the second letter.
Yes, 456, my lord.
Second June letter.
Yes. This is a communication made with us by the, my lord, Odisha authority, because we wanted to know under Right to Information Act how you are doing all this. How come you are giving documents? Now the reply is please come to number 5, my lord. The pro forma was designed by the agency as per their requirement, where it was mentioned that project cost estimated if available, as it was not mandatory requirement by the agency, so it was left blank. Actually, my lord, what is the value of the work that is not there? Kindly come to 159 and 160. $160 or even 159.
4.
Hmm.
Project cost
It
line.
could have been a 10 work for 10 rupees also, who knows? It could have been a work for 100 crore also.
159.
159 and 160. Para 4,
160.
serial 4.
Yeah.
Project cost estimated if available. Because we were also curious to know, anxious to know, about what was the value of the work they have done it. So this has been devised by the party.
That is what the office says.
That is what the Odisha authority says.
This whole
So
form
what
and
is,
certificate.
my lord, where is the transparency in the process?
Performa was designed.
Huh.
This whole document.
So the whole document was designed by them basically, where they obtained these signatures.
Yeah.
Yes. Now, my lord will kindly come to the affidavit, which is very important.
So is there a requirement to give the value of the work?
No, it's not there. Value of the work is not there. No. But in any case, my lord, a party who would be in a position to provide 54 mobile medical unit, I think one mobile medical unit cost hell of a lot. So therefore, my lord, the party's financial, capacity is a factor which cannot be discounted.
The point is, and it's prepared by them.
Huh.
They gave.
Now, if your lordship kindly comes to the affidavit of the respondents number 2 and 3, paragraph 4,
Page?
page 354, my lord.
Para
Para F. How it starts? Paragraph 5F at page 354. That with regard to the statements made in paragraph 6, Roman 17 of the review petition, the deponent begs to submit that as per the tender criteria, vendors have not uploaded the original copy of the user certificate, but 2 number of them uploaded certified to be true copy out of the 3 eligible bidder, including the petitioner, and 1 bidder, that is respondent number 4, uploaded the photocopy of the same. So, my lord, from page 81, perhaps we can show 89 that what is the requirement? Requirement is original copy. Appendix A, attach user certificate in original. That's why I said, my lord, this expression has relevance, which I'll advert a bit later. Now, this is how, my lord, it comes to.
And they've accepted it's not. So there are different.
Now, my lord, what is fraud? Section 17 of the Contract Act is very clear. Contract Act from there.
But what about you? You have
My
also
lord,
not given.
I am unsuccessful. My lord, I am successful. Lord, to that I'll come little up. My lord, why in spite of dismissal of SLPI before your lordships, I'll have to satisfy your lordships on that also, which I'll do. And regarding my locus, I'll definitely come. Let me complete it this part, my lord. Fraud means and includes any of the following acts committed by a party to a contract or with his connivance or by his agent with intent to deceive another thereto of his agent or to induce him to enter into a contract. The suggestion as a fact of that which is not true, by one who does not believe it to be true. The active concealment of a fact by one having knowledge or belief of the fact. I think, my lord, in my humble understanding, subject to what your lordships may say, this is a case covered by 17(1) and 2.
Any other act fitted to defeat?
Any other act fitted to deceive. In a sense, my lord, this is very wide and comprehensive. Now, my lord, in spite of dismissal of SLP, how I am in a review jurisdiction? Yes. My lord, first submission on that count would be, my lord, because I am alleging fraud, fraud vitiates everything including Solemex. Despite the judgment of a court also, my lord, there could be, still I can maintain. If your lordship would kindly have
Kuldeep Singh.
Payappa's case, my lord,
Page 1.
page 221, my lord. If your lordship would kindly come to para 22.
English judgment is the Legerous.
Yes, yes.
Legerous Bisley is there. I
Yes,
think.
yes, yes.
Legerous.
Para 22, 231.
Legerous Bisley is there.
Yes.
But prior to that, that famous judgment by Kuldeep Singh, first line itself,
Yes.
fraud vitiates everything. What was that judgment?
My lord, that Smith versus East Ilo.
No, this 94-1, SCC 1. Chengavaria Naidu.
Yes,
Jagannath.
yes, it is there. SP Chengavaria,
Yeah.
Naidu.
And Leatherus is there, it is based on
Yes,
Leatherus
yes,
versus Bisley.
yes, yes. If your lordship would kindly come to para 22, my lord.
22.
It is thus a settled proposition of law that a judgment, decree, or order obtained by playing fraud on the court, tribunal, or authority is a nullity and honest in the eye of law. Such a judgment, decree, or order by the first court or by the final court has to be treated as nullity by every count, superior or inferior. It can be challenged in any court at any time in appeal, revision, writ, or even in a collateral proceedings. Then 39, my lord. At page 236. The above principle, however, is subject to the exception of fraud. Once it is established that the order was obtained by a successful party by practicing or playing fraud, it is vitiated. Such an order cannot be legal, valid, or in consonance with law. It is non-existent, non-est, and cannot be allowed to stand. This is the fundamental principle of law and needs no further elaboration. Therefore, it has been said that a judgment, decree, or an order obtained by fraud has to be treated as a nullity, whether by court of the first instance or by the final court. And it has to be treated as non-est by every court, superior or inferior.
You have read which paragraph?
My lord, 22 and 39.
30.
38 also actually relevant.
In fact, 22, 38, and 39. Now, if your lordship would kindly come to 38, my lord, then it explains everything. The matter can be looked at from a different angle as well. Supposing a case is decided by a competent court of law after hearing the parties and an order is passed in favor of the plaintiff applicant, which is upheld by all the court, including the final court. Let us also think of a case where this court does not dismiss SLP leave petition, but after granting leave decides the appeal finally by recording reasons. Such an order can be truly be said to be a judgment to which Article 141 of the Constitution applies. Likewise, the doctrine of merger also gets attracted. All orders passed by the court authorities below therefore merge in the judgment of this court, and after such judgment, it is not open to any party to the judgment to approach any court or authority to review or recall and reconsider. So this is the general proposition. What is the exception? Exception is fraud.
We are not even in this, because it's in limine.
In limine. Now, my lord,
Could I?
could I do this? Etu dim na?
Noida.
Noida. Now, my lord, this judgment I'm relying, my lord, 2025 6 SCC 717, para 38. My lord, now, my lord, we have noticed that in 90s, my lord, the moment there was a violation of Article 14, starting from Sri Lanka Vidyarthi, my lord, the scope of interference was made really wide. So, moment there was a violation of Article 14, we had seen judgments of the Supreme Court where the normal rule was to interfere. Now, my lord, over a period of time, now we see, my lord, some sort of restraint is being exercised by the courts. And finally, now, as we understand, the preponderance of judicial view seems to be that unless it defies logic in a contractual matter, normally court should stay away. It must result in manifest wrong committed, or it must be expressly against the public interest, then only. But even then, my lord, this para 38 assumes some significance. Secondly, it is crucial to recognize that when a contract involving a state instrumentality like
Which
Noida,
paragraph are you referring?
para 38 at page 742.
38.
Second, it is crucial to recognize that when a contract involving a state instrumentality like Noida significantly impacting the public, the metes and bounds of judicial review ought to be expanded. The guiding principles is that every state action must prioritize public interest. If a governmental action disproportionately favors a private entity at the cost of public welfare, it is liable to be struck down as invalid. As rightly acknowledged by the High Court also, the state is duty bound to act equitably and in accordance with the public interest doctrine, ensuring that no action harms the broader public interest. My lord, I think, my lord, it's a silver lining in the dark cloud for persons appearing for the petitioner. So, my lord, some scope of interference has been, my lord, reiterated now, which was diluted in between. Now it appears that some ray of hopes are. Then, my lord, on the SLP part, my lord, despite dismissal of SLP, how come we have come up in review petition, my lord? For the simple reason, my lord, the order by which our SLP was dismissed, though it is not a what is not a dismissal in limine, but nevertheless it was a non-speaking order.
Leave not granted. So
Leave was not granted. So it still remained an SLP.
non-speaking.
So therefore, and non-speaking. If leave would have been granted, thereafter this two-line order would have been passed, then, my lord, it would have attained finality. There would have been a merger. Now, my lord, if your lordship would kindly come to page para 26.2, 2019 4 SCC 376.
P7.
2019 4 SCC 376, paragraph 26.2.
It opposed Kunhaya. Kunhaya is the Lahoti.
She was aware of that Kunhaya Ahmed's case, and that is reiterated. As your lordship got it, my lord, we reiterate the conclusions relevant for these cases as under. An order refusing special leave to appeal may be a non-speaking order or a speaking one. In either case, it does not attract doctrine of merger. An order refusing special leave to appeal does not stand substituted in place of the order under challenge. All that means is that court was not inclined to exercise its discretion so as to allow the appeal being filed. If the order refusing leave to appeal is a speaking one, giving reasons for refusing grant of leave, then order has two implications. Firstly, the statement of law contained in the order is a declaration of law by the Supreme Court in the meaning of Article 141. Secondly, other than the declaration of law, whatever is stated in the order are findings recorded by the Supreme Court which should bind the parties thereto, and also the court, tribunal, or authority in any proceeding subsequent thereto by of judicial discipline. The Supreme Court being the apex of court of the country. But this does not amount to say amount to saying that order of court, tribunal, authority below has stood merged in the order of the Supreme Court, rejecting this special leave petition, or that the order of the Supreme Court is only an order binding as a res judicata in subsequent decisions between the parties. Anyway, my lord, we are covered by Roman 4. So that is why, my lord. So, my lord, in other words, despite refusal of the Honorable Supreme Court to grant leave, my lord, we can maintain the review petition. So therefore, my lord, to sum up my arguments, my lord, first of all, it's a case where the technical bid of respondent number 4 was considered to be responsive despite the minutes of 26/12/21, whereby the tender evaluation committee itself mandated that in view of the inconsistencies and ineligibility of the documents, clarification should be sought, which was never done. On the contrary, my lord, in 23 itself, the SLA was issued and it continued. And secondly, my lord, now they are trying to justify by relying upon certain documents, which are all, my lord, not pre-existing documents. I can appreciate, my lord, if these documents would have been pre-existing documents, then they could have taken note of. So these are not pre-existing documents. These are all documents which are post last date of submission of the bill.
And never before NHM.
And it was never before the authority. If it was never before the authority, now their satisfaction based on this will not help them. Their satisfaction should have been derived when they did this took the decision to issue the SLA.
But 159, 160 were before them.
Not there, my lord. No, yes, 159 is a defective.
Therefore they had sought clarification.
My lord, see, my lord, 160, they say this date is not 36/21.
Yes.
It is of 2016. If it is 2016, then it is beyond 3 years. How can you rely on that? In any case, that was not the part of the tender.
There were too many anomalies. How did they?
Now,
flag
the
them?
page 395 are all the clarification which came subsequently.
No, clarification is by a communication. That document, we cannot say that they are basing
lord.
this document to award the contract.
When decision to award the contract was taken,
Yes.
then all that was before the authority was 159 and 160.
160, correct, yes.
Nothing else. Now, on that basis, how they arrived at the satisfaction? That is
How
the
did
point.
they?
That is where, my
In the
lord.
meantime, the work was already granted.
Yes.
Yeah.
Therefore,
Thereafter
my
it
lord,
will-
yes, para 11 of International Airport Authority will come into full play. That even the authorities are as much bound by the conditions which they set for others for performance. That is my humble submission, my lord. So therefore, I'll respect.
Closure.
And my lord, what happened? They have issued a closure letter in our reply. Excuse me.
413.
If your lordship, if your lordship would kindly
Their
come to
reply.
page 41. No. Document pan ase. Closer. Please come to my lord, page number 413.
413 আমাকে কইছে wind up,
When they are
416
6 or 8 of the bar. Now on 17/8/25, they have issued this communication, my lord. Rather, we have been asked to wind up our operations by 31/8. Page 413. And page 416, respondent number 4 has been asked to take over from first.
Phone number?
4, my lord. A communication of event date 17/8/25.
Yes.
At 413, we have been asked to wind up and withdraw from operation. And R4 has been directed to take over from first. And eventually our prayer is, my lord, this whole thing should be redone, my lord. Let them issue a fresh tender. And let whosoever gets it, let them get it. And we are an eligible party, my lord. That is how we are also entitled to apply.
Participate in the tender.
Okay, yeah, अभी नया होगा.
Yes.
So that is my humble supposition. My lord, with a lots of kind permission
Yes,
is another matter.
Yes,
Deep
yes.
level.
But here I'd like to point out one minor factual aspect. Page 55 of the minor distribution. The minor judgment minor passed by the honorable court during the adjudication of the minor main writ petition.
55.
55. Lordship will see para 7 is at page 58.
Good debate.
Page 58, para 7.
Just a minute. 58.
Eight. Here I am to point out that, my lord, so far as the petitioner is concerned, one statement has been made, my lord, he was not, my lord, he was found to be not qualified in the technical stage. That is not the fact, Lordship may see para 7. The technical which were evaluated by the respondent number 2 on 7/1/23, wherein 3 bidders, including the petitioner and the respondent number 4, was found to be eligible. And on so and so financial which were open. So, my lord, his technical bid was found to be, my lord, valid. And my lord, the financial bid was open and he was found to be not to be a L1 bidder. So accordingly, my lord, we selected the respondent number 4 in the present review petition. So I am clarifying that part, my lord. It's not that, my lord, he has been, my lord, disqualified. Respondent 4 has been made qualified. My lord, that was the argument made. Now, Lordship will see, my lord, what was the prayer in the writ petition at page 65. Lordship has recorded in para 23. By
Page
page 65.
65.
Lordship will see, my lord, the first prayer, Lordship has quoted it. If you appreciate the preliminary ground questioning the maintainability of writ petition, the main prayer made in the writ petition is liable to be looked into, which is extracted herein below. One says to quash and set aside the entire tender process initiated in terms of e-tender to maintain and operate the mobile medical unit of operation that was so and so issued by the respondent number 2 to grant extension. So these was the two prayer to squash the entire, my lord, tender process. My lord, nowhere in the writ petition as well as the present review petition, the minutes of the selection committee has been put to challenge, whereby the respondent number 4 was selected. Lordship, you may kindly note that, my lord. Even, my lord, in the review application. They have pointed out
First on first prayer.
to quash and set aside the entire tender process initiated in terms of e-tender to maintain and operate the mobile medical unit operation data so and so issued by the respondent number 2. That is the NSM authority. So they played for quashing of the entire tender process. But, my lord, the minutes, my lord, whereby, my lord, the selection of respondent number 4 or 2 in the writ petition was held, my lord, that has not been put to challenge. But that is the main decision.
Yes.
Now, in the writ petition, my lord, after, my lord, when they were not successful, they, my lord, preferred an appeal before the division bench of the honorable court, and that was dismissed. While, my lord, thereafter they preferred the SLP before the honorable Supreme Court. During the adjudication of the, my lord, SLP, an order was passed by the honorable Supreme Court at page, my lord, 156.
Yes.
Lordship will see, my lord, very innocuous order, page 156 says, original records have been brought by the learned counsel for the state of Assam.
This is 17/1/2025.
Yes, your lord. It says that, my lord, the original records have been brought by the learned counsel for the state of Assam. The same may be inspected by the learned counsel for the petitioner and the private respondent, released in the week commencing 27/1/2025. So according to the petitioner, the
Yes.
review applicant, my lord, this additional new facts which now they, my lord, have brought in the review application, this has come to their knowledge when they peruse this records, which was, my lord, allotted to them to have the inspection, but as per the order of the honorable court.
Correct.
Now, my lord, subsequent to that, the hearing was done, my lord, they submitted all this, my lord, whatever arguments they have made today before the honorable court were submitted before the honorable Supreme Court, and the entire record was placed before the honorable Supreme Court. Thereafter, that order was passed. Maybe it is not a speaking order.
Where is the order?
Of dismissal, my lord.
Yes.
75.
One.
75.
170. My lord,
No,
170.
75.
75. Page 75. 18/3/25. It is subsequent to the perusal of the record. 18/3/25. We are not inclined to interfere with the impugned judgment, hence the present basis is dismissed. Pending application, if any, else then disposal. After perusing everything, my lord, the records were placed. They argued, my lord, after perusing the records, this particular, my lord, lacunas or discrepancies in the, my lord, documents of the respondent 4, they could, my lord, gather the information, my lord. From that, my lord, verification was, my lord, offered by the honorable Supreme Court, pursuant to the earlier order. And thereafter they argued. And despite that, my lord, this was the final order passed by the honorable Supreme Court. Now they say that, my lord, this is a non-speaking order. It cannot be merged. If that be so, the order of the division bench still stands. My lord, there is a standing order of the division bench dismissing, my lord, their writ appeal, upholding the order passed by the honorable court. So that order still stands. Secondly, my lord, the entire tender process was a e-tender. Every bidder, they are supposed to upload their technical bid and financial bid in the particular portal. And every bidder has got the access to the, after the technical bid is open, my lord, every bidder has got the access to the technical documents of every participating bidder. Moment it is open, they have the access. These documents, my lord, experience certificate, whatever they are now pointing out, they say that, my lord, the new discovery, that were there in the portal, my lord, after opening of the technical bid. It was within their knowledge, my lord, whatever document was there, it was uploaded.
In a e-tender, every bidder has got an access to the
Yes,
documents
they've
of.
got the key, man. After the technical bid is open. Not before that. Moment we open it, my lord, they have the access, because that's why Lordship will see. After that, they used to file writ petitions because they have got the access to those, my lord, documents. They point out, my lord, these are the lacunas. Despite that, my lord, the authorities have selected so and so bidder as a valid bidder, technically valid viable bidder.
But this page 159, 160 were their documents.
This was the experience certificate submitted by respondent 4. It was there at that point of time.
Are you contending that it is not because of the order of the Honorable Supreme Court of 17/1/2025 from which they got the knowledge, but they had the avenue
Yes.
to have this knowledge the moment the technical bids were open,
Opened by the tendering.
tender committee?
My lord. That is my humble submission, first of all. Secondly, they say that, my lord, these particular clarifications that we have received were not, my lord, sought for before the last date of submission of bid. My lord, that part will come when a particular new document is submitted by a bidder after the last date of submission of bid to supplement this, my lord, technical bid. Supposingly on a particular document, there's some, my lord, discrepancy. If they, my lord, want to submit a corrected document thereafter to us, then we will refuse. But to have a clarification from our side, that is always there. We have not sought for any new document from the bidder. Man. Now, why we have to sought for that document? That I will now point out from my affidavit. We have annexed the document.
Clarification then, we're keeping it now, 2025.
Lordship will have page 383.
383.
Okay.
Well, page 383. Lordship will see it is dated 28/4/2025. Well, this letter we have communicated to the chairman cum collector, District Mineral Foundation, Government of Odisha, Sundargarh, Odisha. They are the authority who has issued that to my lord experience certificates. So we have to sought for clarification from them why my lord it is there in this particular letter, 383. And this is part of the writ petition. We have served a copy to the writ petitioner also to maintain the transparency, my lord, that we are doing this. And why, my lord, I am saying, Lordship will see, my lord, the Supreme Court order or dismissal order was passed on 18/3/25, and this is a subsequent date, 28/4/2025. Now may I read the letter? This is to kindly request verification of the above referred letter of award. Lordship will see in the reference, my lord, number 1, LOA number 35 DMF 4/1/2020. I will place it, my lord. Already that has been relied upon, pointed out by the petitioner side. Now may I read it? This is to kindly request a verification of the above reference letter of award and performance certificate issued to MS Community Action Pro, there is a camp, for the operation of mobile medical units in Sundargarh district. Camp has cited his experience in a tender process for operation of mobile medical unit under National Health Mission Assam and have sought qualification based on the above experience. Now next para is important. A representation in this regard has been submitted by Hindustan Latex Family Planning Promotion Trust, that is the petitioner hearing, raising authenticity of the documents, which was forwarded to us by the Additional Director General of Police by the email dated 3/4/2025. Lordship will see the date, my lord. They have raised the issue after the dismissal of the my lord SLP. They have raised, my lord. We have not sought for the clarification, my lord, on our own.
Now, this forwarding is by the
Yes, yes.
DGP. This is not the date of the representation.
No, my lord, at that point of time, my lord, this particular issue was raised after that, my lord, because they have made a statement in the review application. I will point out, my lord. In view of the above, we were kindly requested to confirm whether the LOA and the performance certificate mentioned above were indeed issued by your office and whether the contents are authentic. A copy of the certificate is enclosed for your ready reference. We will likely say to so and so. Lordship will see now, my lord, what was the clarification they have given, and that particular document is at page 385. We sought for clarification on this particular document.
Yes.
386, man, 386. This was the first clarification we got from that authority of Sundargarh. With reference to the subject and letter cited above, I am to inform you that the agency camp has been engaged under DMF and providing different devices in Health Department of Sundargarh district. As per your inquiry, I am to confirm that the letter issued under reference as mentioned below were issued to camp agency are authentic as per record. First, 1. Letter number 35 DMF dated 1/4/2020. Subject is operation and management of 37 numbers of ambulance, 13 numbers of Mahaprayan services in Sundargarh district out of DMF fund issued by collector so and so. Next is my lord 3749 so and so dated 24/12/16. Proposal of operation of medical or mobile medical units. Collector and district Magistrate Sundargarh is the issuing authority. Third is my lord 3697. This is the letter number dated my lord 36/21. Certificate of satisfactory performance. These are my lord under dispute. CDM and PO Sundargarh. Next, my lord, fourth letter is my lord 3698 dated same date 36/21. Certificate of satisfactory performance CDM and PO. And lordship will see now they have said that enclosed letter number so and so, they have enclosed it. After getting this particular information from them, we sought for further clarification. Had there been some malafide on our part, we would have, my lord, straightway given the work order or would have allowed the petitioner to go on with the, my lord, work, new allotted work.
But despite that, my lord, lordship will see at page 391. In this particular reply also, we found certain discrepancy. We wrote again, page 391. This is the letter dated 23/5/25, issued from the, my lord, National Health Mission to the collector and chairman cum managing trustee district, Mineral Foundation, Sundargarh, Odisha. Clarification on discrepancies observed in reference to your verification letter dated 8/5/25. That, my lord, that document at page 386. Again, we sought for certain clarification. In para 2, we have stated at the outset, we express our sincere appreciation for your timely response and for confirming the authenticity of the documents. However, upon a detailed review of the information provided and internal verification, certain discrepancies and points of clarification have been noted. These are summarized in Annexure A enclosed herewith. Given the seriousness of this matter, we request you kind attention and clarification on the points listed in Annexure A for ensuring transparency, due diligence and accountability in the verification process. Now, lordship will see, we have given a chart now this time, my lord, pointing out the discrepancies that we have found in their, my lord, clarification letter. Page 393 is the Annexure A of that particular letter. The letter number, my lord, 1546 dated 8/5/25. Mismatch in the LOA date in the cover letter versus the copy of the LOA. As per the copy of the LOA attached, the date of LOA is stated to be 4/1/2020. However, the date of LOA mentioned in the letter is 1/4/2020. Kindly confirm the actual correct date of LOA. So we sought for that clarification. Next, my lord, that experience certificate 3697 number, my lord, 3621. Particulars, issue date and clarification verification on the content of the letter. Please confirm the date of issue of the letter, whether it is 3621 or 3821. At the top, it was 38. While signing it, my lord, the authority signed it to be on 3621. So that clarification is sought for. Next, in the same document, as per experience certificate, LOA number reference is 35 DMF dated 4/1/2020. And the MOU agreement is dated, my lord, 20th March 17. So, my lord, if the LOA is of, my lord, 2020, how can the agreement be of 2017? That, my lord, we have sought for.
But Mr. Gogoi, these clarifications you have sought for after the litigation.
Well, because they now.
No, after the litigation. What was the basis of you being satisfied when you had allotted, when you had issued the service level agreement on a 28/6/2023?
Well, that part, whether they can raise the issue now, when.
No, we are asking you.
Well, that they have, my lord, pointed out to a particular, my lord, minutes in the repetition which they have annexed. According to them, my lord, they have came to know about that particular minutes while perusing the record before the Honorable Supreme Court. Now, in that minute, there was a observation made.
No, you have said that you have taken all the due diligence now. That in spite of one clarification, you sought for more clarification.
No, my lord, why I'm
First
saying.
clarification, you said that yes, you have given a letter, all are authentic, but we still find
Yeah, that number is,
discrepancy.
my lord,
So, why the exercise which you are now making, what prevented you from seeking an explanation or clarification at that time before you actually
well,
issued?
that part, my lord, Lord Civil see, my lord, they have verified, they found it to be, my lord, to be in order. That
Who?
minute, no, the
The-
tendering
the-
authority, my lord. My lord,
Authority.
why I'm saying is, my lord, in the minutes it is there, they have, my lord, placed it on record in the writ proceeding. But, my lord, nowhere in the grounds of review, they have taken any ground that pursuant to the minutes, my lord, we ought to have taken the clarification in, because this is a review application, they will be binding by the, my lord, grounds taken. Not a single ground.
No,
my
no,
lord, is taken
what
point of.
happened after this, after the further clarification sought?
Yes.
What?
Now, my lord, clarification thereafter was submitted by 394, page 394.
Your annexure 393 is answered by 394.
Yes, madam. 27/5/2025.
If they will not taken the ground of review.
Yes.
But here the letter number 1546 dated 8/5/25, mismatched in the LOA dated in the cover letter versus the copy of the LOA. As per copy of the LOA attached, the date of LOA is submitted to be 4/1/2020.
Which is this letter, 1546?
Well, that is there, my lord.
Your letter, is it your letter?
No.
No,
There-
85, it is called 85.
Yes, it is their letter, my lord, the reply,
Hmm?
first reply. Clarification, my lord.
85, yes, right.
First clarification.
Right.
So, my lord, what
This
they
is a
reply-
386.
386, yes.
386, okay.
As per the record, the actual or correct date of LOA is 4/1/2025, letter number so and so for operation and management of 37 numbers of ambulance service plus, comma, 13 numbers of Mahaprayan vehicles. So 37 plus 13 is 50. Next, my lord, these are the two experience certificates. 23697 issued by so and so 36/2021. Lordship will see what clarification they have given. As per record, the actual experience certificate issued date is 36/2021. Next, number 3697, number so and so 36/21 is the original experience certificate issued. Number of MOU service, but LOA and date of ambulance service has been entered wrongly in the experience certificate. As per the record, the correct LOA of MMU services letter number so and so dated 24/12/16, followed by agreement dated 28 March 17. So they have now clarified. It was otherwise, my lord, they mentioned it as 2020. So,
Then immediately we'll put the question because this was what was argued.
my lord,
3 years preceding.
my lord, we are waiting because of this litigation. and
No,
all.
16 certificate.
My lord.
This
No,
certificate is
there-
a 16.
Yes, there are two experience certificates submitted.
Yes.
It's not that, my lord, there is no such condition that if one contract was.
How many certificate is required?
No, up to them, my lord. We want
No,
that
no,
they
no.
must have 3 years experience. It can be, my lord, by 2 works, it can be by 1 work. It's up to the, my lord, bidder to satisfy the authority that he has the experience of executing a similar work for a period of 3 years. Maybe not by one contract. That's why he has submitted 2 experience certificates of 2 separate works. Lordship will see, my lord, serial number 3698 and 23697. So dates are-
Section 5, clause number 2. It says at least 3 years experience in community medicine. One experience will be enough.
1 may or 2, whatever is there, madam. Here relied.
So even if you ignore the second certificate, the first one will be within this period of 3 years.
No, my lord, even then also by, my lord, that 3 years period can be counted by relying upon 2 work orders also of separate periods. It will have to be 3 years. Maybe by 3 works, 2 works.
At least let us see the language at page 84.
Yes.
Assignments, yes. It's more than.
Page 84.
Yes.
Section 5.
Clause 5,
serial
section
number
5.
2. The bidder in case of a consortia, all the participants shall be at least 3 years experience in providing medical care at community level. In support of this, a statement regarding assignments of similar nature successfully completed during the last 3 years should be submitted as per performance.
Last 3 years.
So maybe 1 year or 1 work or two works, doesn't matter, my lord.
Assignments, plural.
Concern is, my lord, for the last 3 years, they will have, so that, my lord, they have the experience of performing similar nature of job. It may be by 1 work, by the second also it will suffice. Now, my lord, here, my lord, the third row of CBC. As per record letter number so and so, dated so and so.
These certificates,
My lord.
let us assume that these are authentic certificates. There is no, you have verified.
Yes, but the main.
And then what is the tenure of this works?
3 years.
This, my lord. That will be there. Let us see the certificate, my lord.
About 17.
Lordship will see at page, my lord, 397,
Yes,
3697, 397, my lord, page.
yes, yes.
Lordship will see the date of commencement of service and before the duration of contract, 5 years.
Yes, for 5 years.
In the next letter, page 398, the second
Yes.
experience certificate. Serial number 2, duration of contract 3 years. And commencement is 2nd of March 2020.
You are reading 397.
Lots. 96 and 97, 97 and 98, my lord. The duration, one is, my lord, 5 years, another is, my lord, 3 years. Commencement, my lord, 5 years starts from 1st of April 2017. My lord, next serial number 3.
5 years. Yes.
And in the next page, 398, serial number 2 and 3, Lordship will see, my lord. Duration is 3 years. Commencement 2nd of March 2020. Even, my lord, in the first document also it covers. They recently, the second document has also been submitted, that is 398. Also, we will see the serial number 6 also. I just wonder why we sought for the clarification.
Yes.
Here, my lord, serial series says, my lord, they have the experience of 15 numbers of MMU, 25 numbers of MMU. So far as, my lord, this work is concerned at page 397. And in page 398, sorry, 398. Here, my lord, there is a second line. And the right hand side, my lord, page 397 of para 6.
Yes.
Here's the experience of 25 numbers of mobile and medical unit minus 3. And in the next page, 398, same para. In the third line, para 6, in the middle, my lord.
Yes, 54.
54 numbers of GPS, so fitted ambulance linked to central so. Here, my lord, we sought for a clarification, my lord, in respect of 398. The actual work was for 50 numbers of mobile medical units. How it became 54? They clarified that subsequent to that, 4 more were required. Accordingly, letters were issued, they provided this. 2, 1 by 1 letter, 2 by 1 letter. So we have given the experience certificate to be 54. That is what they say in the clarification. My lord, we have taken due diligence, my lord, before, my lord, issuing this particular letter, but whereby they are supposed to start the work from 1st of September. Otherwise, my lord, we need not have to, my lord, exercise this particular, my lord, clarification from the authorities. After, my lord, the SLP has been dismissed. Now, Lordship will see at page 400. No, page 405. 405. There is another experience certificate which was issued by, my lord, Directorate of Health Services, Raipur, Chhattisgarh. There also we have sought for the clarification as per the objection raised by the lead petitioner or review applicant hearing after dismissal of the review petition. The clarification is there. 408 is the translated copy. Four zero eight. Next is there.
Yes.
408, it is connection, it says, in connection with the subject cited above, it's my lord pursuant, it's a clarification given pursuant to this later it is
28-4.
28 at page 405. They subject to the organization intro. Later dated, it is 26/11/2019, my lord, not 13. Experience certificate issued to organization that camp by later dated so and so 26/11/19, not 13. Then they have given a photocopy. That lordship will find at page 4098. Same content, same my lord letter, but they say lordship will see down below. Lordship will see down below of this letter 4098. This seems my lord as if it is 9 man, 3.
Which page?
Page my lord 4098.
4098.
Clear copy. 4098.
Yes.
It is in Hindi, my lord. Down below, my lord, date given in by the signatory. It's in 26/11/9 was written something like, my lord, it seems to be 33. Whereas at the top, lordship will see 26/11/2019. Then, my lord, the document also, my lord, whatever was submitted to us, that we have forwarded to the authority at page 407, that document is there. Because, my lord, the contract in the body of that, my lord, certificate is of 2019. So they clarified it is 26/11/19, not 30. At the top, issue number and the date is there.
Yes.
So after having clarification from the authority, thereafter, my lord, the NSM authorities took the final decision after having approval from the government and all, my lord, to, my lord, allow the work now, since, my lord, the litigations are over. And the period was 3 years, which can be extended to another 5 years. To the respondent number 4, and from 1st of September, it will be started. Now, my lord, so far as the right of the, my lord, present review applicant to, my lord, re-edited before this honorable court after having been failed before the landed single judge division bench as well as the honorable Supreme Court by way of a review application, that too by on the plea that while perusing the records, I will I'll show it from the pleadings of the, my lord, review application, that they have found these discrepancies, and therefore they want that, my lord, the order should be reviewed because of the discrepancies. That part, lord, may I point out, my lord? In the writ petition, they are in the review application, they are pleadings. Lordship will first see page 7. Thus, I want to read it, my lord. Thus, I want to point out page 7, para 6. Sub para Roman 1, it continues.
Page 7.
Of the, yes, review application.
Para 6, yes.
Roman 1, 2, my lord, now I won't be reading this, my lord. Thus, Lordship will now turn to, these are various facts which were placed before this honorable court at the time of consideration of the writ petition. This is their own statement. Page 18 now, para 27, the facts have been placed. In para 7 now, they say, upon being aggrieved.
Page 18.
Page 18. Upon being aggrieved by the above stated circumstances, the petitioner was constrained to prepare a writ petition bearing so and so. Then Lordship will see page 20, para 13. This is regarding the order of the honorable Supreme Court. 13, page 20. By order dated 17/1/25, the Honorable Supreme Court was pleased to allow the petitioner herein to inspect the original records brought on record on behalf of the state of Assam. Respondent number 1, a true copy so and so that the Honorable Supreme Court by order dated dismissed. Now 15 is relevant, is related to para 13. It is pertinent to mention here in that when the petitioner was given liberty to inspect the original records brought on record on behalf of the state of Assam, Respondent 1, the petitioners were only permitted to make note of the date and details of the document. Subsequently, petitioner obtains copies of the documents from the website. Lordship will see which website. That, my lord, the portal, which documents are already there, my lord, after opening of the technical bit. Lordship will may I read, my lord, the last line of page 20, para 15. Subsequently, the petitioner obtained copies, some of the documents from the website, others from the respondent authorities. Experience certificates were there, my lord, in the website, means the e-portal, not the website actually, in the e-portal. Finally, when all the documents were obtained, the petitioner was astonished and surprised to find that the documents filed by responsible for the bidding process were rife with discrepancies. However, in the meantime, special petition got dismissed. So they came to know about this prior to dismissal. Lordship will see, my lord, the last line. However, in the meantime, so when they came to know, SLP was dismissed. So they were aware of these facts when the SLP was dismissed. After, my lord, perusing the document and, my lord, taking a printout of those, my lord, from the website, e-portal. They, till that day, they had the access. And it was argued, my lord. That's why, my lord, I am saying, my lord, they are trying to reopen. My lord, what is the remedy available under 226? Read petition. If you are, my lord, agree in the, you are not successful, read appeal, then SLP, then what remains, my lord, review. Or, my lord, miscellaneous application. Now they are willing review. For last 2 years, my lord, same, my lord, thing, pointing out one or the other, my lord, the entire tender process has been sabotaged. I'm not saying, my lord, they don't have the right. They have the right to, my lord, execute. But, my lord, they are unsuccessful for all along, my lord, from the petition to the SLP. Even if they say that, my lord, since it is a non-speaking order, it cannot be merged. Then also, my lord, division bench stands. There is our, my lord, division bench, my lord. That order stands. So where do they stand now, my lord, in this review petition, my lord? It is there, my lord, lacuna, that they have not produced those documents, my lord, at the time of, my lord, hesitating before his honorable court, my lord, way back in 2023. It was there in the website. And this is their pleadings, my lord. Now, lordship will see what is the grounds, my lord. Para 17, page 22, Roman A, B, and C, these are the, my lord, only grounds that has been reiterated in the ground column, my lord. Not about some clarification. Page, my lord, 22, 17, subpara A, B, and C, regarding the discrepancies they have now found during the, my lord, pendency of the SLP. During the pendency of the SLP, they have found these discrepancies. Now they are hesitating in the, my lord, review application. They ought to have hesitated. In fact, I say they hesitated. That was not considered and it was dismissed. Meanwhile, they said, well, that line may be, my lord, taken note of. There's their pleadings. Para, my lord, 17A speaks about that later, my lord, experience 3697. I'm not reading, my lord, whatever is there, they have already argued. Then this, my lord, 3621, whether it should be 36 or 3821, that was the, my lord, discrepancy they pointed out. We have got the clarification. Then, my lord, page 25, C is regarding the next, my lord, experience certificate, that is 2611, 2013. That also I have placed, my lord. Now, lord, we will see the ground starts at para 33, page 40. That's why I say, man, where is the discovery of new grounds? It was already there. You came to know before the dismissal of the, my lord, SLP. After perusing, cannot be a new ground, my lord. And, my lord, one more thing I would like to point out, there is separation of facts, my lord. I will place it, my lord.
Yeah, no separation and this.
At least I think, my lord, there is separation of fact. My lord, grounds, my lord. Here they have reiterated, my lord, regarding those two documents, my lord, the experience certificate. Nothing more, my lord. There is no ground that my additional thing has been now brought in. And regarding that, my lord, I have already submitted, my lord, these are not additional documents that has been placed by the, my lord, bidder. We can have a clarification, my lord. We have not sought for any new document, new certificate from them. We have sought for the clarification. Thereafter, upon being satisfied, finally, we have decided that now, since all the litigations are over, we will be, my lord, allotting the work to the respondent number 4. Had he committed fraud, my lord, we would have taken, my lord, penal action as per the tender provisions, my lord, he would have been blacklisted. Even, my lord, during the continuation of the contract work, if the petitioner can, my lord, place some document, some, my lord, authority, he will be, my lord, anybody, be the petitioner or the respondent, my lord, or any future bidders, my lord, that will be taken care of, my lord. Fraud will be, whether fraud has been committed or not, it will be decided by NSM authority, the contract party, my lord. Not by this honorable court upon some, my lord, allegation made by, my lord, writ petitioner, the participating unsuccessful bidder, my lord. Fraud will be committed upon us, my lord. That's why we sought for a clarification. They cannot today come up and say that there is a fraud, there is a fraud. So, my lord, this is my humble submission. Only one judgment I would like to place, my lord. And regarding this document, my lord, page 456, these are, my lord, documents between, my lord, internal communication of the petitioner as well as some authority, which cannot be the basis now, my lord. That being 2625. That, my lord, pro forma and all, my lord, they themselves submitted that, my lord, that value is not required to be mentioned, my lord. That is a categorical statement made by the, my lord, petitioner side. When lordship posed this direct question that whether it should be mentioned or not, they said that not required. This particular document fails, my lord, by their own submission, my lord. One judgment, my lord, very common judgment. Just I want to place, my lord, Justice Mandal, para 22.
Para?
Para 22.
What is the citation of Jagdish Mandal?
My lord, 2007-14 SCC 517.
Para?
22. I am giving a, my lord, printout. This regarding judicial review, my lord, in contract, but still, my lord, this remains, my lord. Lord, civil suit, my lord, para 22, at page internal page 531.
Yes.
Judicial review or administrative action which is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tender or award of contract, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially a commercial function. Principle of equity and natural justice stays at a distance. If the decision relating to award of contract is bona fide and in the public interest.
Yes, this is.
No. My lord, lordship will be placed on E. That's why the main part I want to point out. Here, my lord, between D and E. Lordship will see, my lord, damage in a civil court between D and E. Thereafter, attempts by unsuccessful tenderers with imaginary grievances. Wounded pride. Here, my lord, seems to be a wounded pride. And business rivalry to make mountains out of molehills of some technical procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. My lord, for last 2.5 years, my lord, we are waiting. Such interference, either interim or final, may hold up public works for years or delay relief and succor to the thousands and millions and may increase in project costs manifold. Therefore, a court before interfering in tender or contractual matters in exercise of powers of judicial review should force my lord, these are two my lord among these questions. That part, my lord, owner's right and my lord, business liability. Because my lord, after rebuilding everything, my lord, they are a my lord, I understand my lord, they are my lord profit making company, my lord. But that doesn't mean that my lord, even after going to the highest level, you again come up with this review application. Try to sabotage again after 2.5 years when you have failed my lord everywhere. And my lord, that
Failures are the stepping stones to success.
not always, my lord.
Somebody big has said, great has said.
My lord, that work order now, my lord, we have already issued page 413 if your losses, my lord. In the affidavit we have annexed, there's a final order we have issued. That they will have to, my lord, hand over to the respondent number 4 and they will continue only till the end of this month. So I'm not, my lord, reading what is there because in the order, page 413.
413.
413 and 416.
Just a minute, please.
And Lordship will see in the.
Just a minute.
Yes, 413 annexure M.
What is this?
My lord, by this order, the petitioner has been, my lord, directed to, my lord, stop by, my lord, 31st of August and to hand over, my lord, to the respondent 4. And the respondent number 4 has been directed to take over in page 416 from 1st of September. And here also we have mentioned about the orders passed by the Honorable Court as well as the Honorable Supreme Court. Based on everything, the decision was taken.
Yeah.
Yes.
Everything has cropped up from the dismissal of the SLP before the Supreme Court. When the.
You're for
I thought the
R4.
report Number 4. Before my friend has pointed out before the Supreme Court, they have access to all the original records. And after going to the records, the Supreme Court has dismissed their SLP. Now, if your lordship take up this page 175 of the review petition. This is a complaint filed by the review petitioner before the police on 23rd of April 2025 after dismissal of the SLP, seeking an independent and impartial inquiry into irregularities and procedural discrepancies in the award of the work order to camp for the operation of mobile medical units pursuant to the tender issued by the National Health Mission, Assam. What it is called, page 175.
Yes, what is this?
This is the complaint filed by the review petitioner before the IGP Admin Assam Police, DIGP Assam Police and AIGP Assam Police. Requesting for an impartial and independent inquiry here in page 76.
Yes.
Page 176, they have alleged that submission of fake certificates, number 1. Then they have given the numbers which have my friend has already pointed out, the certificates.
Yes.
Number two, non-adherence to the service level agreement, SLA timeline. Number three, incomplete tender closure process. 177 page. Prior track record of camp, and this was issued by some Avanish Avasti of the review petitioner. And this has led to the investigation by the NHM, and which accordingly they have sought for a clarification from the
Yes.
they have sought clarification from Sundargarh as well as Raipur mission directors. And the Lordship has gone through the annexure, which has clarified all this position that these are all in accordance with law and these are genuine. There is no false documents. So, and now presently the work order has already been issued and we are supposed to start our work from the 1st of September 2025. Now, only because of this proceeding, this has been halted. In my humble submission, there is no case. Then, in fact, they have failed to make out any ground for interference for review of the order passed by this honorable court on 14/5/2025. 23, madam. I'm sorry. 4/5/2023. So there is no ground as such from ground 33A to W. There is no such ground taken by this honorable court, which is a new thing has cropped up, which was not within the knowledge of the petitioner prior to the dismissal of the SLP. This is my humble submission, madam.
Any reply?
Any rejoinder?
Yes, Your Lordship. 5 minutes, quickly. Lordship, this is a very curious case. It's turning the case on its head. What is the argument? First argument is review is not maintainable. That's against law. Khuda Ahmed and Kodai Distillery settles that. I'm not even on that. What is NHM's argument? Their best point is that you had all the documents. That's their best point. Their best point is we have averred that we did not. By the time we got the documents, SLP was dismissed. We did not get a chance to argue it before the SLP. SLP did not say heard and dismissed. SLP did not say heard, leave granted, dismissed. SLP did not say heard, findings and dismissed. SLP is dismissed in limine as just SLP dismissed. So there was no hearing. And we have no instructions, no averment to say SLP was heard and thereafter.
What is the meaning of in limine?
In limine is without a speaking out. That's what Kunda Ahmed and Kodai Distillery says. If it's in limine, it's without a speaking order. So if an SLP at SLP stage, that's the paragraph. If at the SLP stage, there are two options. One is dismissed. One is dismissed SLP, but with reasoning. In that situation also, there is no merger, but whatever the reasoning is will be 141 and res judicata. But it still remains at the SLP stage, therefore there is no leave granted and therefore there is no merger and a review is maintainable. That is the law settled by Supreme Court.
What has the division bench said on your review?
Division bench says go back to single
Where
judge.
is
Yes, Your Lordship. Lordship has that at page 157.
157.
157. Yes, sir. In accordance with law. Sit down. They said they thought it prudent that the single judge must, since it's a review of the original single judge, go back to the single judge. 157. Lordship has third paragraph. Having heard the learned counsel appearing for the parties, we are of the view that if the review petitioner wants to withdraw the review petition with liberty as prayed for, the same can be granted only if the law permits the review petitioners to approach the learned single judge by filing a review petition. And the law permits us, is our case. That is Kodai, Kundayaman and Papaya, because Papaya says anytime, any state, even collateral. And why do they say that? There's a reason why Papaya says that. This case is turning everything on the head. The evaluating agency is now holding it against us that we did not evaluate the documents well. At the end of it, that is the sum and substance of their argument. These documents were available on website. You should have checked. They don't need to check. We should have checked those documents. We did not. We did not. We did not. We say that we did not. It was not our job to check their documents. Their A to Z of their case is, why did you not check? It was already on the portal. My answer to that is, why did you not check? And that is the crust of our matter. We have come to your lordship to say 159, 160 and 162 on the face of it. You are giving 39 districts, 139 MMU units to an agency who has the audacity to submit 3 certificates where the date doesn't match with the date, signature doesn't match with the date, cites MOU of 2017, LOA of 2017 and says there's an agreement of 2020. The date is 2017, they signed 2013, even now they continue to say 2013 and they certify for work that is to happen in 2019. And the NHM says, it's not my business to look at it. And Lordship may kindly, the most important point is page 164. The NHM detected this, gave them 3 days to come back with proper certificates. They are silent on that, no averment. We have taken that stand on in a review petition. They say, but we followed everything. Where did there is no record. Now we have checked the website. There is no record better than what is there. Did they come back? I have not heard a single argument. 163, 165, it is their own stand. They detected it. Yet they chose to give without asking for record. And their biggest grievance now is that we are holding back. Why? Because we are checking. And this is the state of Assam and NHM. And your lordship is correct. The 90 days 4.5 is not a subject matter of review. But it does talk about conduct.
Which one? 90 days?
Lordship, under SLA, Mr. Chaudhary, under the SLA, you have to operationalize within 90 days. If you don't, Lordship has seen that at page 344. So the SLA agreement now that is in existence with CAM requires CAM to operationalize everything within 90 days. If they don't do 90 days, then it says 2 consequences: cancelled and performance security forfeited. And we've shown you documents from page 322.
No, that action had been taken at whose instance? Your instance.
Sorry?
That action would be taken, if at all, at the instance of an unsuccessful bidder.
No, Lordship, it's not about unsuccessful bidder. I am talking about conduct. Lordship, look at the holistic picture. What are we saying?
Stick to your case, madam.
Yes. No, I'm on.
If the NHM has not taken some action against the successful bidder in spite of the being required to do something, can you raise this question?
Yes, your lordship.
On
Public
what-
interest.
Public interest.
No, lordship.
You were a competitive bidder. You failed.
Lordship.
Not in the technical bid. You failed in the financial bid.
Yes, your lordship. May I make my point about 90 days? Why am I saying 90
That
days?
is not a part of the review.
No, lordship.
You stick on a review.
No, lordship.
Your review, we have understood that the review is mainly based on an allegation of fraud.
Yes, your
You
lordship.
stick on that. We are hearing that. We have heard
To
that.
corroborate that, I am on conduct of NHM.
You cannot bring up new things in a review, madam.
All right, lordship.
Jurisdiction is very, very limited,
Yes,
as you know.
Yes, your lordship.
Only
Lordship,
three
I am on.
conditions.
I am only trying to say
Make
that.
out a case with the 3 conditions.
Lordship, may I tell you what I'm relying on, actually? Lordship, may kindly go back to Noida toll, 2025, 6 SEC, Feb 717.
Yes.
If the government action disproportionately favors.
Please do not repeat. 38 has been placed.
Yes, Your Lordship.
No need of repeating arguments. If there is anything a rejoinder to his argument, kindly place that. We are not rehearing again.
Yes, Your Lordship. No, Your Lordship is asking.
38 we have seen.
No. As an evidence of disproportionate favor is the fact that notwithstanding that their certificates say anything, they detected that certificate,
Madam,
they still gave them time.
The fact that we are exercising review jurisdiction.
Yes, Your Lordship.
We are not hearing a writ petition.
Lordship,
We have
I'm
already heard this.
Yes.
We have given a judgment. Now you have to make out a case that the judgment needs requires a
Yes,
review.
Lordship.
Only on that.
Yes, we are on those three documents, page 159, 160, 169. And there is no answer to say that we should have seen it before and we should have brought it to light. It was their business, they should have seen it, and the fact that they did not see it is the grievance of our review petitioners. And Lordship, I'm obliged to Mr. Dhar, he's absolutely correct. The starting point of this investigation and clarification is pursuant to our letter in page what was that page? Page 170.
That email.
178. Lordship may come back to page 178.
175.
Yes, Your Lordship, 175.
28/4/2025.
Yes, Your Lordship.
Yes.
And Lordship may take a look at the NHM's reply. It was not that they were worried. It went to CVC. And
Yes.
CVC investigated, that's why they're doing it. And Your Lordship, I emphasize, the whole investigation has happened because of review petitioner. And it should not have happened. Our grievance says this was NHM's business to look into it. They did not look into it, and which is why we have come to here. And to say that why did you come so late is no answer, because they should have seen it in the first place. Lordship, there's no other point. Huh? Lordship, I have already made the point of the page 165.
What is 165?
Page 165. 164, 165. Minutes of the meeting, they detected it.
164
They
is
detected it.
26/12/2022.
Yes, Your Lordship. They detected it.
Yes.
They said, come back in 3 weeks. There is absolute silence. They did not come back. There is nothing to, no document. And Lordship, I completely agree with NHM's argument. Fraud has to be determined by them. My problem is that the absolute inaction and favoritism, that they've not even bothered to see what is glaring on the face of those certificates. And the basic submission is that now giving clarification does not evidence application of mind. On the basis of what is there on record, you applied your mind to give camp the bid. Was that a correct bid decision? That is our. Now, if you come back and say no, this is there, even those are not relevant. Because Lordship may kindly come back to page 395, the chart. वो कहाँ गया मेरा? Reply. Lordship, in 2025, they are now coming back with these clarifications, and NHM is accepting it. And Lordship, in clarification to 3621 column item 2, they're relying on LOA of 2016 and 17. NHM has never seen it. It's not about a record. So on what basis did NHM grant? On the basis that there is a LOA of 2020 followed by a agreement of 2017. On the face of it, and Lordship, I'm relying on Papaya and on Noida to say it was disproportionate, it was fraud, and therefore a nullity, and Your Lordship may.
Harry Khansa, where is the writ petition?
कुछ बोलना है?
Writ petition, or is it?
Your Lordship.
One, the separation part I have stated.
No, just a moment. I'm just trying to clarify something.
It's the-
वो कुछ बोलना था
This 3 days, whether you have taken that point in the repetition, madam?
Yes, your lordship,
Where-
paragraph 18, I think. Review,
In the writ petition?
no, review.
No, in the writ petition.
No, no. Because we didn't, lordship, we did not, that is why we've come in review.
No, this point was available to you. That 3 days time was granted to them. This is a minor.
Yes, but we were not really on documents and on
No,
veracity
but
of
did you
documents.
take up the point even?
No, we did not.
You did not even take up the point, madam. In the writ petition, it was not even argued, it was not even pleaded.
Yes, your lordship, which is why we've come to review.
Can you?
Lordship, 47.
Can you?
Yes, your lordship.
If
under
matters are
47.
before you and you do not take it up, you cannot become wise tomorrow.
Lordship, we say we did not. Under 47, your lordship.
Under 47, 3 clauses.
Who,
In spite of due
who from
diligence.
discovery of new and important
Yes,
matters or
that
evidence which
3 days was a new fact.
Lordship,
It is at minutes of 26/12, 2022.
Lordship, now you're putting the onus of evaluating on a,
No,
on a
not on
party.
evaluation. It's
No,
not a
Lordship,
question of evaluation.
There is no question for us to go and minutely look at MOMs. We
Oh.
challenge, Lordship, any,
You will take
appreciate.
such a convenient stand.
No, Lordship,
Some minutes which will favor you will take full advantage.
Lordship,
If there is a minutes of meeting which gives somebody 3 days time.
correct.
You have not even mentioned that point in your.
Lordship, we believe that NHM will be doing.
Your belief will not do, madam. Your belief will not do. Okay.
That suppression part, my lord, may I please?
No, we checked up in the writ petition if it was taken at all.
No, the
I don't think
suppression
so.
part, my lord, one, my
That
lord,
is why I asked, madam.
material fact, my lord, regarding suppression.
No, it's
Lordship,
okay, we
you
have
see this,
closed-
no,
closed
my lord, same issue, my lord. They preferred it petition before the High Court of Odisha.
Upload
Lordship,
it,
you see.
sir.
Where?
Lordship,
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 may I
you see.
clarify one bit?
We're closing, yes.
My lord, the first page, Lordship, you see the first page.
Yes,
This is, my lord, from petitioner to the, my lord, mission director NHM.
yes.
It is dated 28/6, I suppose.
Hmm.
Second para, it has been come to your notice that the tender awarded to CAMP is based in part on documents that is currently under judicial scrutiny, especially the user certificate 3697. Lordship will remember that letter number, experience certificate 3821 and 3698 submitted by CAMP concerning the operation of MMU in Odisha has been challenged before the so and so. And Lordship, they have given a copy of this particular document along with this letter in the second page, as well as the order and my lord, status of the case. Everything was given to us. Not a single whisper in the review petition that this is under challenge. They are adjudicating there, and again they are taking a chance here. You must, my lord, come with clean hands, my lord.
You have
Serious,
not
my
mentioned this.
Lordship, no, I'm not seeing.
No, now by orally they
Lordship, may I
cannot justify
clarify
that.
the MOM? Lordship,
No,
the
no.
MOM was, we discovered the MOM only during inspection. And it was not uploaded. This is the internal meeting of the NHM. We are not privy to it.
My
So
lord,
there
this,
is no ground for us.
yes, my lord, regarding MOM.
Just a moment, just a minute, just a minute.
Lordship, if we had those documents, we would have made that a ground of writ petition, not come in review. Lordship, this is not even in sight. This we discovered from record on inspection on 13th of October 2023. Correct? Sorry, 17 January 2023. So this is not on public website. And this is an internal document. There was no opportunity for us to avert or challenge or rely. কি বিষয় মাত্র
ওড়িশার কি পেন্ডিং আছে আপনার আপনাদের আমাদের same document we are reading.
Just asking for the documents, yeah. It has nothing to do with it.
Okay. Heard. Vicky Chaudhary, that is senior counsel assisted by Ms. G. Goswami for the petitioner. Also heard Sri P. Google, then it standing counsel for the NHM. NHM. And Sri A. Dhar, learned counsel for the respond number 4. So, We'll reserve the judgment. We'll consider.
Just one last submission, my lord, so far as that particular document, my lord, she is now referring to that minutes, my lord, where 3 days time was granted.
Yes.
That document is not there in the grounds, my lord. Page, my lord, Lordship will just note it. Ground A to ground W, my lord, I have perused it, if they can, so there's a.
Paragraph 18, page.
No, paragraph will not do, you'll have to take it as a ground for review, not a single whisper from ground A to ground W. Lordship will just record it.
Then Lordship may also record my.
Pleadings will have to be followed by the grounds, my lord. There is not a ground for review, my lord.
Page 8, para 20, page 26, para 18.
I'm only, my lord, making submission regarding the grounds, my lord, taken in page 40, para 33, ground A to ground W. Not a single whisper. There's not a ground for review. They will have to confine it to the grounds, their own pleadings. They may make a statement, my lord, in the other paragraphs, but while taking the grounds for review, this is not a ground for review.
If NHM's answer to no application of mine is that I did not over it, well and good.
I am obliged.
Okay.
Like,
Madam, you
Lordship,
just have a look at this.
yes,
I
Lordship.
have given.
I'm-
Their document, my lord.
No, Lordship, we were not getting the documents, so apparently they filed it asking for the documents. It's not the same subject.
Whatever
matter.
with the issue, man. They are challenging, there is the issue subsidies. That is their language.
No, those documents is under judicial scrutiny, is not
Yeah.
asking for a document.
RTI, my lord, is not a, my lord, authority, my lord, High Court. To furnish.
Lordship,
inspection.
you wanted inspection.
At least you should have made a mention here, at least. Your
Lordship, even
You're on conduct. If you're on conduct, your conduct is also have to be above board. Okay. Yes.
We are not been pressing, notice also not has been issued. We filed it asking, but we got the documents, which is why we're not pressing it.
Aren't you required to make a mention?
Lordship,
After all, rich jurisdiction, equitable jurisdiction.
after review petition, we filed it. This is after review petition, your Lordship. Yes, sure. Huh? Look, this petition after review petition.
Then, my lord, review is pending here, how they can record there, my lord. Either way, my lord, there, my lord, how you. Oh, even in us. 19.5. 19.526. It's on 35.20. Prior to review, my lord. Lordship will see the date of the review application. It is filing date is my lord 19/5/25 before the Odisha High Court. That is there in the checklist. And copy was served to us in so far as the review is concerned on 31st.
Here
Prior
it's
to-
concluded, judges is reserved. You're making things complicated, Eddie.
Lordship may grant status quo till judgment.
We'll pass judgment as soon as possible.
Okay, 14.5.
Lordship, we filed at 14.5
Yes.
and that letter is? Lordship, the letter is after the review.
Yes.
Which one?
Right on 14.
14, this new letter of suppression of facts. Letter date 2.
Madam, it's not about the letter, it is about the filing of the writ petition before Odisha as well as the filing of the review petition before the honorable court. In Odisha, it was filed on 19/5/25.
Yeah, and this is 14/5, before.
Thus, I am placing, my lord. I am not
Before,
saying-
so it's no. Tell from your lordship, why did I not aver it? It's come after, not before. And it doesn't pertain to this. And camp is not even a party there. This is further investigation. Lordship, we have to hand over 31st, lordship, and grant status quo.
Where have you filed an application?
Yes, yes, your lordship.
What is the application?
My IA fund. Yes, yes, we filed IA.
IA for what?
For status quo, your lordship.
No, that's just IA file along with the review application, not
Yes.
my lord after issuing of this, my lord, order by NSL.
For status quo, operations,
Okay,
because we are continuing in operation.
Order has been issued. There is a
31st we'll hand over, until 31st, status quo will.
No, madam, that order is also, that is also, not- that if to, you might have, you can still challenge it separately. But how much will be successful, that's a different idea.
No, lordship,
Matter.
we prayed for status quo. Right now, we are continuing, so let us continue till
You
on the
continue on what basis?
on the basis of status quo order.
No,
and
not on the basis of court's order.
initially on the basis of court's order, and then NHM not withdrawing work.
Your initial work was for how many years?
5 years. 5.
When did it expire?
It was not extended.
22,
Not extended.
22.
When did it expire?
Because we required the service and because of the
When did it
pendency of the
expire?
litigation, they were allowed to continue.
Lordship 22.
And you are working till now?
Yes, your lordship.
On the
Yeah,
basis
they
of
were
status quo?
Lordship, and they're allowing us, lordship. We are investing and we are providing no
Ask
complaints.
them if they allow, we have nothing to say.
No, lordship, till the judgment is delivered, lordship may grant status quo.
Sorry. We'll deliver the judgment as soon as possible.
Lordship may grant us 2 weeks' time to hand over then. 31st.
We are delivering the judgment as soon as possible, madam.
Lordship, after 31st, nothing will
It
go.
may be tomorrow also.
Then lordship status quo till delivery of judgment.
Sorry.
Right, your lordship.
ये मुश्किल है। ये भी तो लिख दे, ये तो लिख बोले, ये तो काली दी जरूरी। हाँ। Okay. Mata है, yes. It on mata, okay, recording. 10 to 12. What are these?
So as per the last order, they were supposed to file instruction. Your Lordship.
But we have received instruction. I have prepared the affidavit and sent it for vetting. So Lordship,
14 matter, why affidavit is required? You have not filed affidavit. You filed affidavit earlier. Who is responsible for 6? 6 is private
Technical education. Director of technical education.
technical education. If you can please your instructions and 14 matter will not look good to
these are the
defer. What is the matter?
Your Lordship, the petitioners here petitioners are landless cultivators, Your Lordship, and after that they were subject to eviction, Your Lordship. Status quo was granted to them by this court. And they have annual patta as well as and they were paying revenue also, Your Lordship.
Where are the documents?
Lordship.
You have pata?
Yes, Your Lordship.
Where are the pata?
Or the annexure to are the treasury challans, Your Lordship.
Page?
Page 33.
33.
33. Page 39 is of 9/7/73, Your Lordship, dated 3A.
This 48 rupees is for what?
Lordship.
48 rupees is for what? Where is the vernacular?
Lordship, that time, Your Lordship, vernaculars were not annexed, Your Lordship.
All are type copies.
Type copy, Your Lordship.
We need to see what is the. And how much? 48 rupees, 33 rupees. So 320, this is what? This will not do.
Lordship.
This will not be conclusive. We don't know what in 33. What revenue? What kind of revenue? You said Patal, and where is Pata?
No, they're praying for Patta.
I'm praying for periodic patta, Your Lordship. But
This is Axonia land.
Taxonomy.
You consider as per the policy presently there, but we cannot.
Lordship, can it be on any other day, Your Lordship?
No, 2014 matter.
Next week, Your Lordship. My senior will apprise, Your Lordship.
Which place is this?
Saloi Para, Your Lordship.
Where?
Durham.
Where are the impure notices? Page
Lordship,
77.
notice has not been issued, Your Lordship.
Page 77. Yes, what is your?
Our stand is that it's a government land, and land has been by resolution number 10 of Subdivisional Land Advisory Committee held on 7/8/2013. The land was allotted to Director of Technical Education for establishment of a polyclinic in Mongoldo. Polytechnic. So their government has already approved. Now thereafter they have come up. But no land document as regards the allotment whatsoever in favor of the petitioner is not available with us. With the Deputy Commissioner.
Lordship, before
No
that,
such allotment has ever been made in their favor.
before that, no notice has been given to us, Your Lordship, regarding eviction or any other thing. Subsequently, what they have done is they have given the advance position dated 13/9/2013. Page 80, Your Lordship.
80.
80.
Yes.
This is the certificate of handing over of possession of land, Your Lordship.
Yes. Now the who's in possession of this land?
We are in possession, Your Lordship.
What about the Polytechnic?
Polytechnic has been diverted to some other place, Your Lordship. It has been established somewhere else.
No, no, no.
Because of the status quo, my lord.
The construction work was stopped.
No, this is of 2014. After 10, 11 years, what has happened?
So this is what the latest instruction. It is of August 2020.
Understood, but this repetition is of 2014, isn't it?
Yes.
Status quo for the last 11 years.
Yes.
So 11 years, the Polytechnic is not functioning or not been
No,
constructed.
it was not being constructed. Put a stall because of the stay order passed by
Now,
the
what has
government.
happened to the Polytechnic? Has it been constructed anywhere else?
That information I do not have, my lord, but in our.
A Polytechnic will not stop. Is there a Polytechnic at Darang? Maybe in the earlier place, maybe this was a new location, not no. But you have to make out a case. What is your name?
As Gautam, Your Lordship.
As Gautam. Mr. Gautam, you have to make out a case.
Lordship.
Your documents are not there. You have given some translated type copies. The vernaculars are not there. There are certain translated copies which says that this land is revenue land.
Lordship.
Saxonia.
Lordship, kindly give me 3 days time, Your Lordship. I'll get the vernaculars also. The originals are not with me, Your Lordship.
You can apply to the government for allotment under the present scheme.
Lordship, kindly.
But if this particular land is required for a public purpose, we cannot. Okay, on Monday we'll have.
Yes,
Monday we'll have this. Monday.
Can it be on some other, so that I can bring on record the affidavit? It's already set for waiting.
You should have filed the affidavit. You cannot give you time. So yeah, it's your urgencies would be yours.
Yes, yes.
14 years. There is a status quo matter order pending. Yes.
Can it be on Thursday, Madam next? By that time, I'll try my bring on record that affidavit.
Sri A. Bhattacharya, learned, you appear as Revenue Council.
Yes.
Learned Standing Council Revenue has submitted that the affidavit opposition has been sent for vetting and it will be filed shortly. Tara. However, considering that this writ petition is pending since 2014, comma. No, don't say however. This writ petition is pending since the year 2014. Para, taking into consideration the aforesaid spec, time up to.
Can it be on 11th, Your Lordship? 4th?
No, we cannot.
Then on 2nd, Your Lordship.
Time up to 1 week's time is granted to file affidavit. Full stop. List this case on 8th of September. 8th September. If you file, you file. It is made clear that on the next date, this court will go ahead with the hearing, irrespective of the fact whether such affidavit is filed or not. Rest may not be possible today. Yes, Hadarika, which matter?
My lord, I
Will Mr. Goswami? We'll have some other day.
21, 22.
We'll have some other day.
Yes.
If there is any urgency, you can just indicate to our court master, he'll give you a date.
Any day as your lordship.
May it please your lordship, supplementary, my lord, second hearing item, my lord, I am
Yes.
appearing on behalf of Mr. T.K. Tiwari. Lord, on his behalf, I humbly pray that the matter be taken on 9th, my lord. It's a
Okay.
2015
You make
matter.
a request, he'll give.
My lord.
Matter of which year?
It's a 2015 matter, that
Okay,
now
well,
on top. Yes, my lord.
Hello.
Lordship will take date from the court master.